Lordship, I would like to mention one matter. Yesterday's matter, Your Lordship, that Bala Murugan, commercial quantity. I just request this honorable court to make an observation that the observation will not influence the trial court, Your Lordship. It was for the purpose of considering the bail application. Otherwise, trial court will be influenced. One observation, Your Lordship. Very well, to mention tomorrow.
Malad, may I just mention one matter? Malad, in that habeas corpus matter where your lordship has directed the SHO Aberdeen to bring the girl from Kolkata to police, they have brought the girl today. So, Malad, the other side is also present. So, Malad, can we release that girl to that person? That just that direction, Malad.
No, that matter was
Posted tomorrow, Malad.
Tomorrow. Very well. The supplementary list file করতে হবে নাকি? Mona, supplementary list file করতে হবে তো যদি আজকে দিতে চাই।
Other side is present.
Other side, Malad, he is present, Malad.
No, Mr. Tabriz is there tomorrow. No, that
He is in mainland, Malad. He is.
No, but when is he coming back? Monday.
We have talked to him, Malad, over phone. He have instructed his junior.
Very well, then we can take it up. No, what time will you will be give the matter then at 12?
12, Malad.
12.
Great.
Yes, follow with that.
I appear for the petition.
Yes.
Lord, this is an offense under section 22C oblique 29 of NDPS Act, Lord.
Yes.
Lord, the case of the prosecution is that,
In custody for how long?
Lord, I am in custody, Lord, since last, Lord, I was arrested on 21st of October, Lord.
Yes.
And the alleged contraband that was recovered was 61 grams, Lord.
Yes.
Now, Lord, brief facts of the case is that, Lord, a girl who is a college student, she was apprehended, and on being checked, it was found that she was carrying a contraband.
Kullu is a girl.
No, my lord, I am appearing for the person from whom nothing was seized.
No, very well. So girl is who?
Girl is, my lord, I'll just name that particular girl, my lord. Her name appears that, my lord, may kindly come.
You don't have to name her. Anyway, what do you want to show? Yes.
Aanchal Haldar, my lord. It is appearing at page number 13.
30?
13, my lord. Aanchal Haldar. Page number 13. My lord.
FIR?
No, my lord. It is the copy of the charge sheet which reflects that Aanchal Haldar.
Charge sheet.
Yes, my lord.
Yes.
Now, my lord, my name appears at page number 14, my lord. I was arrested, Santosh Kullu, my lord. I was arrested on 21/10/2023.
Yes.
Now, my lord, the case of the prosecution is that on 18th of
What
October,
happened to this S. Mohan?
Lord, S. Mohan is again another accused, my lord, who says the case of the prosecution is that S. Mohan has handed it over to Aanchal Haldar for the purpose of consuming the same. Now, when Aanchal Haldar was arrested, I was taken into custody. I was confronted before Aanchal Haldar, and Aanchal Haldar has clearly stated that no, I don't know this particular person.
Aanchal was arrested, then why would you also be taken into custody?
Milord, both the persons, I'll come one by one, I'll come, Milord. Now, Aanchal Haldar has said, no, I have purchased it from Mr. Mohan, Milord. Then when Mohan was confronted, she could identify the co-accused, namely Mohan, but she was unable to identify me. Now, how they are entangling me in this particular case is, my lord, may kindly come to page number 22, my lord.
Yes.
my lord. Last portion, my lord. Last portion. How I got that particular methamphetamine is that this is my statement, what the prosecution says, my lord.
Yes.
He has stated that last, page number 22, last two lines, my lord.
Yes.
He has stated that I found the packet near seashore near my home.
1 minute, page 22.
Yes, my lord. Page number 22,
Yes.
last two lines may kindly be read, my lord.
He found the packet at.
He means Santosh Kullu, my lord. He has found the particular packet from near the seashore.
Yes.
Now, my lord, my
This is
basic.
part of what?
This is the part of the charge sheet, my lord. This is the only incriminating article, what they say, that it was my statement. My lord,
No, he says that he found the packet at a seashore near his home.
yes, my lord. He means myself, my lord.
Yes.
Myself. They are speaking about Santosh Kullu, my lord.
Yes.
This is the only incriminating article. Subsequent to this, there was a house search that was conducted. The house search ended in no search report, my lord.
Where do we find that?
My lord, my lord, since the case diary is there, my lord, may kindly.
You proceed, then
Yes,
we will
sir.
see the case.
Now, my lord knows one thing very well, my lord. In the absence of any recovery, in the absence of any statement made by the co-accused in terms of section 67 of NDPS Act, because Tufan Singh's judgment, my lord, knows that any statement of a co-accused in terms of section 67 will not be used as a tool to convict any other co-accused person. This is the second principle.
Tufan Singh was more on 161.
Yes, my lord. Yes, yes. No, section 67, it is specifically mentioned, my lord. That apart, my lord, when in this particular case, I would say that if your lordships just peruse the case diary, there is no statement of any of the accused person in terms of section 67.
Yes.
There is no financial transaction from me with any of the accused person, nor any recovery is there.
No, but very well. How have you, what is the incrimination against you?
Miller-
Apart from that, you went and found that packet in the seashore.
That is the only thing. The prosecution story is that I found there was one packet lying in the seashore. I had handed it over to one Mr. Mohan, and Mohan then subsequently has handed it over to Anchal Haldar. This is the only thing. But there is no statement of both the accused person in terms of section 67 of NDPS Act to implicate me, Miller.
Very well. Let it.
And in the absence of section 67 statement, Milord knows that application of section 37 as a bar for granting bail will not be there.
Very well. Let us hear. Yes, Ms. Rima.
It is not the case I got it by my younger brother. The case starts when this girl, she was carrying good amount of methamphetamine, which is commercial quantity, to a college where she was studying. So there was an information that she is going to distribute among the students. So she was nabbed near the college. Now, when she was taken into PC, she disclosed that this was given to her by Mr. S. Mohan. Now we got hold S. Mohan. S. Mohan said that it was handed over by the petitioner hearing, who happens to be constable in the police department. Now, where from he got? We interrogated him. He said near his house, there is a seashore. He got one packet from there. Now, Your Lordship, why we are emphasizing on this more? Because firstly, he happens to be a police constable. Secondly, there is a clear-cut CCTV footage which shows that he was handing over that packet to S. Mohan. That we got it from
But
G.
Mr. Elango said that there is no statement made.
You say, but definitely because it,
No,
it
but it
is-
shows from records.
No, I'll show from the record.
Yes.
Lordship may kindly come. Let us, I'll trouble your lordship to read little more.
No, Ms. Dinu, the standard of proof
Yes,
will not be higher or lower because the petitioner is a police constable.
right, understood.
He will be
Lordship.
treated in the same foot.
Lordship,
Yes.
but we have to see, your lordship, how they are spoiling the youngsters.
No, please show us the material.
Yes, now your lordship may kindly come to page 19.
Yes.
I'll just read your lordship. The investigation of the case has been done by SI Abhishek Haldar,
Where are you reading from?
page 19, your lordship, from the first line. Because I have to take your lordship to
Yes.
the entire case, how it was, how he was nabbed. It is submitted that the investigation of the case has been done by SI Abhishek Haldar of PS Aberdeen. That on 1810 at 18:15 hours, a credible information was received from informer that one lady, namely Anchal, who is studying in JNRM College, would come in silver color motorcycle in number such and such at the JNRM gate to sell methamphetamine, and if immediate raid is conducted, huge quantity of methamphetamine drugs can be recovered from her possession. This information was recorded in PS Aberdeen at GD number such and such. This information was conveyed to SDPO South Andaman, Shri Sunny Gupta, IPS, White Secret Note number such and such. Upon such SDPO, directed by endorsing on the secret note to constitute a raiding team for conducting raid for the same. This information was recorded in PS Aberdeen General Diary, such and such, dated 18/10/23. As per the direction of SDPO South Andaman, a raiding team consisting of Inspector Girish Kumar, SHU PS Aberdeen, and Head Constable 417 Vinod Kumar, PC, and others had B. Kumar was constituted, and team was briefed about the purpose of forming the team. Then team departed with investigation kit, drug detection kit, and electronic weighing machine on 1810 at 8:30 hours by SHO and departmental vehicle. At about 8:40 hours, team reached JNRM College and met one Sri Venkateshwaralu and one G. Ramesh of Shadipur to be the independent witness, and they were apprised about the secret information, requested to be witness during search and seizure formalities.
No, and met Sri, these two as independent witnesses means what?
They were there, the local resident of that
No,
area.
my lord. They were the resident of Shadipur.
1 minute, Mr.
Hello.
Gangu, we will come,
Hello.
let her finish, yes.
JNRM falls under Shadipur area itself.
No.
Yes, it falls there.
Yes.
Now,
Check.
so to be the independent witness, and they were apprised about the secret information and requested to be the witness during search and seizure formalities. They readily agreed to be a witness, and then along with police party, an independent witness took position near the main gate, JNRM College. At 18:50 hours, a silver color motorcycle driven by a lady arrived near the main gate of JNRM College, and simultaneously SDPO South Andaman also arrived. The lady was stopped by Lady Constable, and she revealed her name as Kumari Anchal Haldar, such and such, resident of Garacharma near water tank. She was apprised about the information has been received by police team that the police has the reasons to believe that narcotics are in her possession, which is an offence under NDPS Act 1985, and her personal belonging search is to be conducted by undersigned. If she so requires, such search will be conducted in presence of executive magistrate, gazetted officer. Further, before carrying personal search, you have full right to carry the personal search of police party and independent witnesses. She was also apprised that SDPO's South Andaman, Shri Sunny Gupta, IPS, is present with us to witness entire search and seizure formalities, and he is a gazetted officer, and if she wishes, she can also give her search in his presence. Then the notice under section 50 of NDPS Act was served to so and so. There's one page missing, I believe.
Was served to S. Mohan.
It was not, I think one page is
There
missing.
is one page missing. I'll just hand it over.
Sakshi, did you?
I'll hand it over.
ये पेज आपका मिसिंग है यहाँ से वो सर्च की she can also give her search हाँ यहाँ पे कहाँ जाना चाहिए
Look, this is the charge sheet what I have received.
किलोमीटर से हम आ गए ना इनसे पार्ट कर लिया ये देखो यहाँ से Now I'll come to where Mr. Mohan was.
No, but.
Let them read the entire thing, madam. Let them read.
Yes. How can we miss out the
Yes.
page?
This is what the charge sheet I have been received. And it is page number 9, mark, the very next page.
तो इसको कहाँ से पकड़ना
What is this, Miss Zinu?
Yes,
You can't rely on a missing page. We have to read that.
Lordship. Some misprint has been done, Your Lordship.
Misprint, what misprint?
There's some misprint in the charge sheet.
Come back tomorrow. Yes, the charge sheet, comma, which was placed by learned counsel appearing for the prosecution, comma, has a missing page. No, there is a missing page in the charge sheet which was being placed by learned counsel appearing for the prosecution. Stop. Next, list this matter tomorrow. Get the complete, you don't have a case diary?
I have,
have the
I
case
have,
diary.
that is also in the same manner.
Case diary also?
Case diary also, there is one page that is missing.
I have it.
Yes, we may also note, it is relevant to note that the case diary also has a missing page. Stop. So how could you serve that incomplete material to the petitioner, Ms. Zinu? Is that the procedure?
That is not the procedure, Lordship. There is one paragraph which was printed upside down.
An entire page is missing.
No, not entire page. Entire page. Some paragraph is upside down. I'll clear and come back to you.
And give it to Mr.
I'll
Alonso
serve an
before
advance
the
copy.
date.
ठीक करके लगेगा।
Lord, here, my lord, my client was arrested with the possession of intermediate quantity. And I have been languishing, the case has already been charge sheeted, my lord.
Is it admitted intermediate quantity?
It is admitted.
Admitted, I will. Lordship,
Lord.
this morning only I got the
Lord,
copy.
rejected my bill application on the score that 27A is applicable, my lord.
27A, POCSO,
Financial
anything said about it?
Till now, we have never seen that in an intermediate.
Intermediate quantity, then how is 27A applicable?
My lord, they say that there is a financial transaction. Even if there is a financial transaction, section 27A speaks something else. It is harboring or financing someone to engage in this particular thing. In an intermediate quantity, my lord, section 37 will never be applicable.
Show us that it's intermediate quantity.
My lord, my lord, may kindly come. They are accepting. My lord, may kindly come to page number. Page number 29, my lord. 32.85 grams.
So they've added this 11.27 plus 11.
Everything. I'm adding all the things, my lord. 32.85 grams. It's an admitted fact, my lord. Because the section that has been charged, it is not under section 22C, rather it is 22B, my lord. It is an intermediate quantity. 22B, my lord.
This is part of charge sheet.
Yes, my lord. Page number 13 may kindly be seen.
You are in custody since?
Lord, I am in custody since 29/11/2023. More than 3 months, my lord. The statutory period is 60 days.
You were booked under 22D.
22B, madam.
B.
B.
Delhi or Bombay?
Bombay.
My lord, B for Bombay.
Yes. That's it. This is an application for bail. Stop. Next, the admitted fact is that the petitioner was charged under section 22 within brackets B, small b within brackets of the NDPS Act, 1985. Stop. This would also be corroborated. This is also corroborated from learned counsel appearing for the prosecution as well as the charge sheet, as well as a statement, specific statement made in the charge sheet. Stop. The petitioner has been in custody since December or November,
29/11.
29 November 2023. Stop. Next, section 27 hyphen capital A of the Act provides for punishment for financing illicit traffic and harboring offenders. Stop. None of the offences contemplated under section 27 hyphen capital A.
Other sections are also there, Your Worship. Other sections are also there. I don't know how it is being connected.
Intermediate quantity, please, yes, here, none of the offences made out under section 27 hyphen A are applicable in the present case. Stop. Next. Section 37 of the NDPS, the statutory restriction under section 37 of the NDPS Act will also not apply to intermediate quantity of contraband substances. Stop. Next, we are hence inclined to allow the prayer for bail. Stop. CRM DB 03 of 2024 is accordingly allowed and disposed of. The petitioner shall be released on bail on furnishing a bond of rupees 20,000 with two sureties each of like amount, one of who shall be local, and to the satisfaction of the learned special court under the NDPS Act, South Andamans. Stop. The petitioner shall not influence witnesses or tamper with evidence and shall also make himself available to the investigating officer as and when the petitioner is required to do so. Stop. One line you please add above, that none of the offences are made out. After that, next paragraph. We are also informed that charge sheet was filed. Charge sheet has already been filed in. We just saw it.
Charge sheet has been filed on 27/1/2024.
27/1/2024. Stop.
Okay, one line, Your Worship. The trial court should not be influenced by any observation made by this Hon'ble.
Yes, we make it clear that the observations made above are only in relation to the petitioner's prayer for bail.
Much obliged.
Obliged.
Item number 3, WPCT 12/994.
Your Lordship, may I please just move this application? Yes. Here I am the repetition, my lord,
Just wait
and
1 minute, let us have the pages. Impugned order is where?
yes, my lord, the impediment of the last one.
After page 193.
Yes, my lord. Just going into the impediment order, my lord, just may I place the snippets of the fact, my lord.
Yes.
I oppose before the learned tribunal for the grant of the age relaxation on the ground that after 2016, there was a no vacancy was arose with regard to the GTT examination, that is graduate
What is it?
graduate trained teacher. In the last examination, which was conducted, last vacancy, Malit, the Lieutenant Governor is having the discretionary power under the clause 5 of the recruitment rule to invoke the relaxation clause, Malit, and which was exercised in the year 2016. Then after Malit, the entire post of the graduate trained teacher was deemed abolished for the period of 7 years, Malit. By the order of the Department of Expenditure, Ministry of Finance, these deemed posts had been revived, Malit. And after the revival of these posts, Malit, that is 400 something, Malit, these posts were revived. Then after Malit, they issued the notification for the conducting of GTT procedure, recruitment procedure, Malit. The person, Malit, the petitioners who were at
How many before us?
here, Malit, 10, Malit.
10. Yes.
So they were eligible within the contemporary period valid from 2016, 17, 18. But since due to non-contact
Eligible for?
of the GTT eligibility valid,
Yes.
but since the examination was not conducted, the vacancy could not arose. So therefore, they become overaged without appearing to examination valid. So, but pertaining to this clause, my lord, I file an application because of clause 5 to invoke, to direct upon the direct upon the respondent number 1 to invoke the relaxation due to certain circumstances, my lord. This particular, the tribunal below, my lord, they passed the order on the basis, my lord, not going into the merit of deemed vacancy, they simply taken into consideration that they have not given any representation, my lord. But contrary to the fact, the representation is in the record, my lord. Second point.
You had given the representation before moving the cat.
Yes, in order to exhaust my remedy under section 21.
Yes.
Then after, my lord, they period to move before the application, my lord, they the waiting period of 6 months. But here, my lord, the exigency was this: if after the notification in the November 2023, if I would wait for the period of 6 months, the entire procedure would be over, my lord, and nothing remains valid. So therefore, I approach the learned tribunal. Learned tribunal taken into this consideration, dismissed my application without granting any interim order, my lord, and I sought only interim order with regard to the stay of the proceeding till culmination of the decision by the respondent 1 in order to grant the age relaxation, my lord. Kindly come to my lord, RR first one.
Show us your representation first, please.
Yes, my lord. Kindly come to page 37 also. These are the memo, my lord. I filed with the memo, and the representation forwarded by on 28/12/2023. Then after, my lord, the second representation, my lord, 20.
1 minute, 1 minute.
Yes, my lord. Page
So
38.
this is part of the tribunal
Yes,
document.
yes, my lord. Yes,
2012-2023.
yes. So entire representation, my lord, is annexed from page 37 to page 44.
So individually, all of you wrote.
Yes, my lord. Not individually, my lord,
No,
but somehow.
because 40 is a different document. 39A is a different document. 38, 39A,
39A, my lord, it's a
type copy.
type copy, my lord.
No, but then 40 is also a different document.
40 is the copy, original copy, my lord, and 41 is also the different copy, my lord, different representation altogether. That is 12/12/23 at page 41, my lord.
Yes.
These are the representations, my lord, which I filed before the learned tribunal, taken into consideration.
No, so all of you made this representation or only one of you?
No, my lord. 4 or 5 made the representation, my lord.
Yes.
And there was a mass representation, my lord, by a political party, which has also been taken into consideration by the learned tribunal, because once the process was going, so therefore the students approached the political party, and the political party made a representation on the behalf of the student that is also reflected in the order, my lord. So these are there, my lord. Now kindly come to the impugned order, my lord. These are the snippets of the fact, my lord, and how the ratio descendi has been taken into consideration, my lord. Kindly come to internal page 10 of the impugned order, my lord.
Yes.
I'm reading it. Since the respondents have not considered the grievance claim request of the applicant for grant of one-time age relaxation, hence this OA valid. On receipt of advance copy of the OA, Mr. Such and such of the respondent appears to have preliminarily objected the maintainability of the OA on the ground that none of the applicants had submitted any representation claim for redressal of their grievances for fixing the upper age limit of 30 years as prescribed in the vacancy notice dated 7/12/2023. He further submitted that the vacancy notice for filling of the post of GTT has been issued in terms of the statutory recruitment rule 2022, and without challenging the said recruitment rules, the applicant cannot claim the relief as paid for the OA. At this stage, the learned tribunal has asked the learned counsel for the applicant whether the applicant hearing have all approached the competent authority by way of filing the representation, application for redressal of the grievances before filing of the present OA, and if not, whether the applicant intend to file any representation. In response to it, the learned counsel has emphasized that identically circumstanced persons have already preferred representation as well, though representation of political parties, if it is submitted that OA may be decided on merit matter. So this is the discussion valid. Kindly come to para 7 valid. I'm only reading the relevant paragraphs valid. Para 7 valid, it emerges from the report that in terms of the Andaman and Nicobar Administration Department of Education Group B, Recruitment Rule 2023, the respondent number 4 and 5 have issued the vacancy notice dated 7/12/2023 for filling of 380 vacancy for the post of the graduate trained teacher in the Directorate of Education and Nicobar Administration. In the said vacancy notice, maximum 30 year of age limit as on closing date has been prescribed for the applicants, and the relaxation of the said upper age limit has been provided by the government servant up to 5 years, and age relaxation is also allowed to reserve category candidate as well as DRA and contract employees, including the SSCT and administration valid. 8 valid. In the grievances of applicant hearing that though one-time relaxation was granted to the candidate who intended to apply for GTT in respect of the recruitment process held during the year 2013, 2015, and 2016, and instead of maximum age limit of 30 years, the respondents had fixed the upper age limit of 37 years for male and 40 years for female. However, the respondent have not extended the said benefit of age relaxation in the subsequent recruitment rules notified as well as the published the vacancy notice. It is the claim of the applicant that some of the candidate had submitted the representation for grant of age relaxation. However, the respondent have not adhered to the said request and notified the recruitment rules. Not only that, the representation submitted by the political party has also not been considered in this regard. 8.2 valid. It is contention of the applicant that the respondents have granted age relaxation to the candidate who work on contractual basis as well as part-time in Nicobar administration, but have not extended the said benefit of age relaxation to the applicant of the present OA. On such plea, the applicant seek relief for issuance of the direction upon the respondent number 1 to enhance the maximum age limit up to 8 years for general candidate and thereafter conclude the process of the recruitment for the post of GTT. It is also prayed by the applicant that till the respondents initiate the process under the Rule 5 of the recruitment rules notified on 28/6/2023 for grant of age relaxation, the recruitment process be conducted. At this stage, now the deemed vacancies, etc., has not been discussed, my lord. Then kindly come to page 9, para 9. At this stage, it is appropriate to refer the provisions of the section 20 of the Administrative Tribunal Act, which reads as under: application not to be admitted unless other remedies exhausted. 21, 22, 23 mallet. Then there is a limitation clause, that is the section 21 mallet. The tribunal shall not admit an application. These are the proviso discussed mallet. Then after mallet, after referring this clause mallet, kindly come to page 10. What the observation of the learned tribunal? It can be seen that section 21 of the AT Act, it is clearly mandated that the tribunal shall not ordinarily admit an application unless satisfied that the applicant have availed all the remedies available under the relevant service rules as per the redressal of the grievances has taken up in the OA. Further, when it is read along with the section 21A, 21B and 21(1)(b), it is clear that in case where final orders such as the mentioning clause A of the subsection 2 of the section 20 have not been made in connection with the grievances and 6 months have not been lapsed as per section 22, B read with 21(1)(b), the applicant filed before this tribunal would be non-est in eye of law and is liable to be dismissed. Here, ballot, I pause for a moment. Pursuant to the clause 21, if I have given my representation, the representation has not been disposed of, that is apparent from the record mallet. Then after mallet, kindly come to page 12, para 12 mallet. In the present case, undisputedly, the applicants have not filed any representation for redressal of the grievances before the competent authority in respect of the grant of age relaxation to apply for the GTT. It can be seen that after the vacancy notice dated 7/12/2023 was published, the applicant have rushed before this tribunal for redressal of their grievances without approaching to the competent authority. At this stage, it is required to mention that para 6 of the OA, they have referred the para 6 where I have declared that the applicant declared that they have OA file ballot. OA is here, mallet. The declaration under para 6 mallet, it is on page 129, your lords.
No, just give us a date, please.
Yes,
It is, you filed the OA after 28 December.
no, mallet, just. I filed the OA mallet. Yes, mallet, from January 2024.
January 2024. Yes.
Now, para 14 mallet, it emerges from the report that no materials is available to substantiate the aforesaid declaration of the applicant that after the recruitment rule 2023 was notified and subsequently vacancy notice was published on 7/12/2023, any representation in respect to their claim for relaxation of maximum age limit has been preferred by the applicant's hearing. In this regard, it is apt to mention that applicants in para 4.2 10 of the instant OA has categorically admitted that after publication of the vacancy notice dated 7/12/2023, some of the candidates have approached a political party and the representative of the said political party have submitted the representation on their behalf, that is another candidate. This tribunal cannot take into cognizance of any representation submitted by any third party other than the applicant to be treated as
So the
a
representation shown to us, that is by the political party or also by you?
the representation matter, I have filed the memo of application by annexing all the
The representations shown to us, were they made by you or by the political party?
that is made by us only. And the political party.
That was done before the fact.
I have the tribunal. That is a part of the record ballot.
Yes.
Then after ballot. Then the second para is not relevant ballot, 15 ballot. Under this circumstance, the declaration of the applicant in para 6 of the OA has not been substantiated by any material on record. Therefore, it cannot be said that for the redressal of the grievances, the applicant herein have exhausted the remedies available to them to approach the competent authority. In view of this undisputed fact and circumstance of the case, the applicants herein do not fulfill the condition stipulated in section 2021 of the Administrative Tribunal Act. Even for sake of some leniency, there is a no fig leave to cover to help for the tribunal to consider this matter as an exception. This becomes important that the point of the view of the assertion of the learned counsel of the applicant that the word under section 21 is ordinarily and OA can be entertained without exhausting the alternative remedy valid. I put an argument, well, after the vacancy has notification has taken place.
No, 1 minute, please. Let us read
Yes.
Administrative Tribunals Act about. So your only point is that the representations were on record, but they did
Yes,
not.
they are not considered valid. And the second point valid, the section 20 is definition of the ordinarily valid. It cannot be mandatory because once the recruitment process is started within November, if I wait for my outcome to end for the 6th month, the entire procedure will be culminated and my entire rights will be vested.
Well, I'd kindly come to page number 38 of his application. This representation is made by, I can see one GG Matthew. Whereas this GG Matthew is not the party, neither in OA, neither in this application.
Did you mention the cost title, sir?
No, name of the complainant, GG Matthew.
It is a part. He was a part of the
1
original.
minute, 1 minute.
Subhrata Rajvanshi, I can see the.
GG Matthew, where are you seeing it?
Well, page number 38, where the representation has been shown, my.
GG Matthew. Not a
Not a
petitioner.
party. Number one.
Mhm.
Applicant number 1 is GG Matthew, 106.
In a OA ballot. He has.
Wait.
I'm seeing the.
No, why repetition? You have to see the OA. And what is the next point?
The next point is this entire this age thing has been done after the one office memorandum of DOPT where they are changed their the upper age limit and they have prescribed this to all the administration that you also have to do this recruitment rules and everything you have to frame in accordance with this DOPT office memorandum. So according to this DOPT office memorandum, this age limit has been set out.
But the application was dismissed on the ground of not being maintainable.
It not been maintainable, my lord.
Not on the
The
merits.
matter, my lord. And as per the observation of the cat, they have not been able to produce any of the representation made by them, my lord, before.
Just show us, please, that the representations were filed along with the OA.
Yes. This is the page 37, your lordship. These are the application filed under the memo of documents. This is the part of the record ballot.
So 1, 2, and 5,
Yes, but
their representations were there.
yes. And I have categorically stated that each and every applicant before the tribunal has not approached by filing a individual application.
No, but you enclosed three of the
Yes,
representations.
but- And the political party representation ballot at page 166.
The political party representation
that-
can't be
that's a-
considered.
And like,
No, that we will not take into because that's the tribunal
Yes.
has given a.
yes. The only neat question, my lord, lots of people to decide whether my application is maintainable and the DOPT circular they are citing, my lord.
1 minute,
Yes.
let us first see 2021 and all that. One, number 22 করে A দিয়ে দিয়েছে। Page 14 দেখো, internal page 14. Paragraph 11 টা দেখো। আর ওরা যে সেট আউট করেছে তার মধ্যে 21 এ নেই। 21 A, 21 B এগুলো পাচ্ছে কোত্থেকে? নেই তো একদম।
আছে না 21 এটা 2A আর 2B
সেটাই বলছি তো।
21A
paragraph
21
11 দেখো।
হ্যাঁ।
আর যেটা সেট আউট করেছে ওদের দিয়েতে অর্ডারও সেখানেই নেই। ওরাই সেট আউট করছে, ঠিক আছে? প্যারাগ্রাফ 9 দেখো। কি করে তোমার ফাইন্ডিং দিল বুঝতে পারছি না। সমস্যার মধ্যে না যায় মানে আপনাদের এক্সপায়ার ডেট দিলে তাহলে আমি 1 বছরের মধ্যে আমার ছমাস দিচ্ছে ডিসপ্লেসমেন্ট রিপ্রেজেন্টেশন 1 বছরের মধ্যে 6 প্লাস 1 তার মতো রিপ্রেজেন্টেশন তো ইয়েতে ছিল না, আছে 3টে রিপ্রেজেন্টেশন ছিল
এখানে পিটিশন আছে সেই কাজটা দেখতে হবে।
Yes, Mr. Sorry, we don't have your name.
Bharat Bhushan.
Mr. Bhushan. Yes, Mr. Bhushan, show us that, you have shown us the GG Thomas one. Who are the 4 and 5?
Well,
You have shown us page number to show that those were on record. Page 38, not 38. Page 37.
it starts from the 37, your lordship.
Applicant, no, applicant 1 is GG Thomas.
Yes.
Who is applicant number 2?
Applicant number 2, my lord, I'm coming, my lord. The second mallet is of Padmavati, that is the type copy mallet,
Padmavati.
Yes,
And
ma'am.
5 is?
and then after mallet,
Padmavati.
Hmm.
5 is?
just a minute. Then Subrata Rajvanshi mallet, that is as 42A, the type copy, who is the petitioner before you also.
So, GG Thomas is not a petitioner before us.
Now mallet, he has not come before.
I mean,
You want
kindly
before the
just see his
One minute,
representation.
1 minute.
And apart from that mallet, in a tribunal record mallet, kindly peruse the page 44. These are the another representations. Forty-five, your lordship.
Zarina Begum.
They were the party before the tribunal mallet.
Sarat Chand.
Yes, Sharat Chand, Prashin Gain, Parvati Shah, Pradeep Das.
And the notification is dated what?
The notification mallet, kindly come to page 62, that is 7th day of December 2023.
So this representation was made even before the notification, page 45.
With regard to the age relaxation, because the recruitment rule or existing mallet, the recruitment rule pursuant to the clause 5 was existing. So therefore, the representation with regard to the invocation of clause 5 for the age relaxation.
No, so then what was, there was a gap of 7 years, you said. There was a gap on, of what, from 2016 to 2023?
Well, this is the 7 December 2023, the date of notification. And the GZ Matthew representation mallet, it is on 28/12/2023.
No, you told us that there was a gap for 7 years in
The
between.
team abolished was. Yes, mallet. Kindly come to
Just tell us what you had told us.
page 88. I specifically submitted mallet. These posts were deemed abolished from the 2060, which recreated in 2023. This is, kindly come to page 88.
Yes, so, recreated in 2023 in December.
Yes, mallet. It's
But
there in 2023.
Then how could you make that representation in May?
Relaxation mallet. I'm talking about the recruitment rule mallet.
Yes.
The recruitment rule come before that. The notification come after.
Very
When the relaxation was not having this particular clause, we made a representation, and even after 3rd January 2024, after the notification mallet, I made a specific representation to that effect. That has not been considered.
Yes, you were saying something.
But the Zarina Begum's representation made to one US petition @rb.nic.in, whereas this representation has to be made before the Director of Education, my lord.
Yes, but 38 and all that are made before the ministry department.
Ministry, my lord,
Chief
but
Secretary is there.
not to the Director of Education. The concerned department is, my lord, Director of Education.
And when it has been created mallet, recreated, kindly go to page 89. Your lordship will check, establish the link. And another revival ballot, kindly page 94.
1 minute, 1 minute. Yes, Mr. Bhushan,
Yes,
you said that under clause 5 of the concerned rules, only the LG has the
Yes.
power to relax.
yes.
And the representations were made to the LG.
Representation to the, yes, valid. One representation of Padmavati, that is at page 39A, addressed to the Honorable Lieutenant Governor, and the rest of the
39A.
Chief Secretary ballot addressed to the Chief Secretary. And
this my
the students,
1 minute.
Right.
39A.
yes, ballot. And page 44 to their department ballot, education department itself, that it has been addressed.
Yes, but if you see rule 20, section 20, 20 A,
Yes,
21A, section 21A
yes,
says competent authority, a person competent to pass such order.
yes,
So that only means LG.
yes, ma'am.
So representation has to be before the LG. So in that case, only one representation was there,
Yes,
Padmavati.
yes. Because this the file noting ballot, the Department of Education, they preferred the Chief Secretary, then after going the routing in. These are the ballot, kindly consider these are students ballot, who are not well versed about the hierarchy of the system ballot. And on this apprehension, they have given the representation wherever they found suitable, they made the representation. Admittedly, ballot, there's no suppression of fact ballot. So literally, they have made their best of effort to at least give the representation in order to ventilate the grievances ballot. And the power is well lie within the jurisdiction and the discretion of the LG ballot, and it has been exercised. And since it has been deemed vacancy ballot for the last 7 years, there is no recruitment took place, and it has been revived further ballot after the 7 years. Where these students will go ballot, and is the vacancy not only 1 and 2, 390, 400
Yes, you were
vacancies.
saying something.
But the thing is that at page number 39, whatever this represented is the typed copy. Where is the original copy? They definitely have a received copy, my lord.
Yeah.
So why you will supply me? That should be in the record of the CAT. And they are just not the students, my lord. There's some of the students who are generally working in the departments, my lord.
That is not the question. The
Madam.
question is the CAT order, that's all.
My lord.
What they were doing, otherwise we are not going to go into all that.
But
The 10 petitioners before us have challenged an order passed by the Central Administrative Tribunal on 22/1/2024. Stop. The order, the impugned order was passed in an original application made by some of the petitioners, by most of the petitioners before us, and a few more within brackets 13 applicants were before the tribunal, close brackets, praying for a direction on the respondent number 1 being the Lieutenant Governor, Andaman and Nicobar Islands, to enhance the maximum age limit up to 8 years for general candidates and to culminate the process of recruitment only thereafter for the post of graduate trained teacher within brackets GTT, close brackets. Stop. Next, the application, the original application. No, next, the tribunal dismissed the original application on the ground that as not being maintainable, on the ground that the petitioners had not exhausted their remedies under sections 20 and 21 of the Administrative Tribunals Act, 1985. Stop. Alternative remedies. Next, sections, the tribunal relied on, same paragraph, relied on sections 20 within brackets 1 within brackets small o, comma 20 within brackets 1 small b, and 21 within brackets 1 within brackets small b of the Act to come to this view. And was to come to the view that the original application was liable to be dismissed at the very outset. Stop. Next, before we come to our findings, comma, section, it would be useful to refer to sections, the provisions referred to. It would be useful to refer to the provisions relied upon by the tribunal. Stop. We find that section 20, there is no section 20 within brackets 1 within brackets a / b in the Act. Stop. We, however, find hence, comma, the tribunal may have referred to at least 2 of these provisions through inadvertence. Stop. We, however, find, next paragraph, we, however, find that section 20 within brackets 1 contains a bar in admitting an application, bar against admitting an application unless the tribunal is satisfied that the applicant had availed of all the remedies available to him under the relevant service rules as to redressal of grievances. Stop. Section 20 within brackets 2 explains the situations where the person concerned shall be deemed to have exhausted the alternative remedies. Stop. Section 20 within brackets 2 within brackets small a applies where the government or other authority competent to pass such order has made a final order rejecting any appeal or representation made by the person concerned in connection with the grievance, semicolon. Section 20 within brackets 2 within brackets small b looks at a situation where the authority has not made any final order on the representation, and a period of 6 months from the date on which the appeal / representation was made has expired. Stop. Section 21 within brackets 1 within brackets small b deals with a situation where deals with limitation, deals with the bar of limitation. No, delete that. Section 21 deals with limitation, and subsection 1 within brackets small b applies where a period of 6 months has expired from the date of making an appeal / representation and 1 year thereafter, and 1 year and an additional period of 1 year from the date of expiry of the 6 months. Stop. Section 21 within brackets 1 within brackets small b would be relevant to the facts of the present case, since admittedly, the government / competent authority has not made since admittedly, delete the rest, there is no final authority, a final order made by the government / competent authority on record. Stop. Next. We, however, we are of the view, and on considering the material shown to us by learned counsel appearing for the parties, we find that there were 3 representations filed by 3 of the applicants before the tribunal on record in the proceedings before the tribunal. Stop. The applicant numbers 2 and 5 before the tribunal are 2 of the petitioners before this court. Stop. Both of these representations were made on, give us a date please, Mr. Bhushan. 2 and 5, 3 and 5.
Yes, madam.
This Padma, 2 and 5, Padmavati and,
Padmavati and Rajbanshi, madam.
yes, yes.
Yes. Just a
You showed us the pages, give us,
Yes, madam. Kindly 42, your lordship. 41A, 12/12/2023,
and Padmavati,
Padmavati, my lord, that is at
Padmavati date is not there. Type copy.
yes, page 39A.
39, my lord, it's not legible, 26.
Where are you getting that from? 26. There is no date.
The date is, my lord, this copy is with me, my lord. 39A date is not legible, my lord, in that.
Yes, show us the copy, please. What is this? How will we know?
Yes, my lord.
Any date is possible.
Top right hand side, my lord.
What did I say? Made in October and December. Were made before the petitioners approached the tribunal. Stop. The one of these, we find that one of these representations was also made to the Lieutenant Governor. Stop. Next, the impugned, admittedly, comma, the competent authority did not respond to either of these representations by passing any final order or otherwise. Stop. Next. The impugned order shows that indicates that the tribunal proceeded on the absence of any representations made by the applicants before it, and hence invoked sections 20 and 21 of the Act to hold that the original application was not maintainable since the applicants had not exhausted their alternative remedies provided under the said Act. Stop. The tribunal also ordinarily to put out this one. Mhm. 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 हाँ 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 हाँ
Submit within December report. Yes, applications will be. And then we'll start of December. We will expect to see vacancy with the citizen.
What did I say last? The tribunal also interpreted the word ordinarily, quotation marks, under section 20 within brackets 1 against the petitioners. Stop. Contrary to such interpretation, comma, the relevant document states that online applications for the GTT post will start on 9/12/2023 and will be accepted up to 30/12/2023. Stop. The petitioners' representations were already before the government, the department/competent authority before the online applications were to start, and the petitioners rushed to the tribunal in January 2024 with their grievance. Stop. Hence, comma, the word ordinarily in section 20 within brackets 1 should have been construed, interpreted in favor of the petitioners, since the original application, since the petitioners, keeping in mind, keeping in mind the limited window available to the petitioners for making the online application for the concerned post. Stop. Next, the primary reason, however, remains the tribunal specific finding that the petitioners had not made any representations before the concerned authority. Stop. The tribunal, for some unknown reason, completely ignored / discounted the representations which were before it. Stop. We find this to be sufficient ground for interfering with the order of the tribunal. Stop. Next. The other contentions raised on behalf of the council with regard to the merits of the matter, including the power of the authority to relax the age limit, upper age limit, or the petitioner's entitlement to the same on account of the gap of 7 years in between, are not being gone into, since the impugn order, since we have only dealt with the issue of maintainability, which the tribunal ruled against the petitioners. Stop. Next, WPCT 12 of 2024 is accordingly allowed and disposed of by setting aside the order of the tribunal dated 22nd January 2024, 22/1/2024. Stop. The tribunal, we direct the tribunal to yes, yes, since, now, just repeat that line, please. We, just delete that. In view of our finding that the word, that sections 20 and 21 will not apply to the facts in the present case, and further, that the word ordinarily, quotation marks, in section 20 within brackets 1 cannot possibly mean a complete embargo on the original application, on the petitioners in filing the original application, we hold that the original application was maintainable. Stop. The tribunal is accordingly directed to determine or to decide the matter on merits as prayed for, with regard to the praise in the original application. Stop. The tribunal shall decide, shall pass a decision on the original application within, what is a good time, Mr. Bhushan?
Affidavits have been exchanged.
No, but it has been dismissed by it.
Very good. Yes.
It has been dismissed.
Yes. The tribunal shall give liberty to the parties to exchange their respective, to exchange affidavits and decide the matter within, what is a good time?
Maximum act of 2 months.
2 months. And what has happened to the vacancy notification?
That is that they are going to be published on 12th March. I came to know that.
Really?
No, this, yes, 12th February. So I added.
So there are how many applicants? 13 were there?
Yes,
4 weeks it can be disposed of. We will try to.
Yes, take it. Shall be at liberty, just delete. The petitioners shall file, the respondents herein shall file their affidavit within
14 February to 12 February to next week. 12 February to next week or not? 12 February to next week. না এইভাবে যদি এইভাবে কি আমরা করতে পারি যে এই 13 জনের ব্যাপারটা মানে the authority will not take any decision. যদি infectious হয়ে যায় তাহলে কি হবে?
The petitioner, the respondents shall file their affidavit in opposition within 7 days from today. Opposition to the original application within 7 days from today. Reply within,
7 days.
reply within, you make it shorter or what?
3 days.
Yes, reply within 3 days. Thereafter,
If any valid, because it made, suppose everything is document valid, then
reply, comma, if any, comma, within 3 days thereafter. Stop, the tribunal shall decide the original application within
4 weeks for the interview.
within 4 weeks from the date of completion of affidavits. Stop. Next, since we are informed that the respondents will publish the list of vacant,
final selection list.
the final selection list on 12th February 2024, comma, the petitioners are given leave to approach the tribunal for necessary interim relief. Stop.
12 months, that's been short. Yeah, but I'm short. 12 months to Hon'ble. না, ওটা তো বেরিয়ে গেছে, বিলটা তো বেরিয়ে গেছে। তো তাহলে পুরো 12 আছে, 12 এর মধ্যে তো কি যাবে ট্রাইব্যুনালের কাছে?
Tribunal is sitting till when in Pueblo?
Tribunal is valid, to, 16.
16 months.
Till 16th? Yes, then you do it tomorrow. Do it tomorrow.
Here valid.
Tribunal.
Tribunal.
Tribunal is sitting here valid.
You approach the tribunal if you want any interim order.
Valid, so the interim order has already been rejected valid. So therefore valid, I filed this WP.
That was thereafter it was dismissed on the ground of maintainability.
Maintainability.
You have held that it is maintainable.
So that.
With the change circumstances.
Did you follow our order?
I was,
We have held that it is maintainable and we have directed the tribunal to decide your original application on merits.
but this time period is very,
That time period, do it tomorrow. The tribunal is sitting, that's why we asked you.
let the interim may be granted valid for few days, your lordship.
Mr. Bhushan, there may be a difficulty for that. When you have to satisfy that a mandamus can be issued, directing the authorities to relax the age bar.
Clause 5 says LG has the discretion.
Yes,
All right.
yes.
If that is the clause, can we say mandamus? We cannot say that. That
There
is-
are
that is-
online judgments in this. So don't invite
Yes,
our observations on this.
and that will be problematic for you if we say that interim order. Because then the judicial decisions will go against you ultimately.
Yes, valid. But only of the considering the exigency valid,
So
therefore.
we have done whatever we could have done for you, no further.
Let the plain copy of the order now so that I can approach before this tribunal.
Just Stephen get up.
Where I'm saying that there cannot be an absolute embargo,
Embargo.
complete embargo in the facts of the present case. That was the last part of that. Age relaxation তারপরে আবার ধারণ করে দেবে।
Yes.
Item number 4, WPCT 13 of 2024.
My lord, I received the copy today during the course of the
Sorry?
day. I received the copy today, just now.
We can't hear you.
I received the copy just now, today.
Yes, when should we keep it, Mrs. Nag? Then tomorrow?
No,
Yes, this is matter.
it's a,
Sorry?
I require time, my lord.
Short for
No, Judge, you do it, just serve it right now, Mrs. Nag. No time.
My lord, I require time, my lord, I have to do.
No, Mrs. Mr. Lal, what time?
Let it come on Friday then.
Yes, this is matter on 9th February 2024 as paid for on behalf of the respondent.
Item number 5. WBCD 14/2024.
Referring for the petition, my lord. Interim order was rejected by the tribunal.
1 minute, please. Where is the impugned order?
Page 83, my lord.
That's a short order.
My lord. Even not considered, my lord.
You prefer her leave application before a competent authority.
My lord.
So that is what you said to the tribunal.
No, my lord.
Then,
My lord, may I place the facts, my
no,
lord?
no, but that is what the order says that
No, no, my lord.
that she intends to prepare her leave
No,
application for the
if
competent
my
authority.
lord sees my tribunal's application and my prayer, my lord.
Where is that?
My lord. My lord, may kindly come to page number 30, that is page number 52, running page 52. Reliefs which were short for. And the interim prayer.
What is the impugned order transfer?
Relief order, my lord. Transfer order is the subject matter of another original application where a status quo order was passed.
No, so what is the impugned order?
Impugned order was relief order.
Show us
My
the
lord.
order.
Kindly come to the relief order, my lord. That is at page 80, my lord.
18.
80, my lord.
Plans relief means what?
My lord, I have been transferred on 19th of August 2023. That is
Yes.
at page 55. I
Yes.
challenge it before the tribunal, my lord. Tribunal passed an interim order. That is the status quo order. My lord will get it. That order at page 77.
Reconstruction of a service book means?
My lord, my service book is missing from 2018 onwards, my lord.
Yes.
And it was not reconstructed. I have even made complaint. I have initiated criminal complaint and all that has not been reconstructed. Now, my lord, the challenge was one of the challenge was with regard to my transfer order dated 19th August 2023. Now, my lord will find in the said order, fourth line, my lord, according to his instruction, learned counsel for respondent.
would submit that the applicant is working at GV Pant Hospital since 5 years and the interim transfer order has been issued in terms of the transfer policy. The claim of the applicant for grant of
So what was the interim order?
interim order, my lord, status quo. If my lord come in,
What was your prayer? Interim order of status quo, that was.
no, no, my lord, my prayer was to not to give effect to the transfer order.
Very well.
And my lord, there is an admission that I am discharging my duties in the same place of post.
Very well. So they said that the respondents will consider the
Yes.
your
If
representation.
my lord sees last second paragraph at page 78,
Yes.
it says in the meanwhile, it is open for the respondent to consider the representation of the applicant if not already decided and communicate the decision thereof to the applicant. Till such time, status quo of the applicant as on today be maintained.
Yes.
Now, my lord, the 4-week time was given to the authorities to file reply. They have not filed the reply. My lord will find it in next order of the tribunal at page 79.
And interim order to continue.
My lord. Now, my lord, admittedly, till date, they have not filed. The matter is posted on 20th of February. That is before the circuit is on 20th of February 2024.
Yes.
Now, my lord, by this order, on twofold, I have challenged the transfer order before. That is the subject matter of other original application. Here, my paramount consideration was that there is a transfer policy as per which the transfer ought to be made within April to June, my lord. April to June of any
Okay, so what is this order at page 83 then? 83 is against the.
relief order dated 12th of January 2023. Only confined to the relief order because transfer order.
Yes, but then you say that you want to go to the competent authority. Who is that? Look at page 83.
No, no, my lord. There, if my lord kindly see the prayer in my application, my lord, just now I have shown to my lords.
No, so what does this mean?
lord,
It's not
I said-
well and she intends to prepare her leave application before the competent authority.
My lord, we have sought for stay of the said order, my lord, and we have challenged the relief order dated 12th January 2023. Now the court did not consider it at all. If my lords comes to page 52, what is my interim prayer which I have made before the tribunal?
January is the relief
My
order.
lord, my lord. That is at page 80, my lord. Now the transfer is the subject matter of an original application. Relief order was issued. Already there was a status quo order. That original application will become infractuous. And I have challenged it on twofold, which they don't have any reply. Because
Your short point is that the CAT was supposed to hear the matter on when it is
20th, my lord. It was
20th
20th.
February. So before that, the authority could not have relieved you.
Well,
that is what you want
yes.
to say.
And if it is relieved, my lord, my original application has become infractuous.
Yes, but the CAT also gave the tribunal also gave leave to the authority to.
Consider my representation.
Yes.
Consider my representation. And my lord, if my lord sees page 80, the consideration was not at all on merit the representation which I have submitted. Page 70 is my representation, my lord. My two grounds are, my lord, my daughter is studying in class 9. Second is, my lord, the transfer policy say transfer ought to be made in the month of April to June, their own transfer policy. Now, my lord, in judicial review, if a transfer policy, they did not adhere to their own transfer policy, definitely judicial review lies, my lord. And if this order is implemented, my other original application will become infractuous. Now, my lord, kindly see the order, my lord, 80. Why
Relief means now you don't have to work for them anymore.
No, they have transferred me to some other place. Up to 31st January, I was allowed to work, my lord.
Yes.
Up to 31st January. And thereafter, immediately I have approved this honorable court. Now I am nowhere, my lord. After the order date 12th January 2023, whereby they relieved me from 31st, my lord.
আছে transfer policy আছে তো সেখানে আমরা যদি ধরুন এটা থেকে আমরা যদি বলি যে না এটা এটা চলে যাবে এটা চলে যাবে মানে কি তার মানে হচ্ছে যে হ্যাঁ, মানে এইটাকে ইন্টারফেয়ার করা হবে এই যে আমরা বলি যে till 4 weeks নাকি it's not always decided. Yes, what do you have to say?
Yeah, first of all, he is not right now, he is not challenging the transferring order. But anyhow, transfer order are the part of the service order that can't be challenged unless there is something very arbitrary. I have judgment to support that. A second thing is that by first order of status quo, that has given liberty to the authorities not to decide her representation and then status quo will automatically.
Yes.
No matter they have decided on the status quo goes and therefore she has been removed from now. But she came with another contention before prior to this last order. Our contention was that her child is studying class 9. But her transfer order is of 11/5/2000 did not transfer order. Actually, the draft transfer order was input by the department on 11/5/2020. That is also as per the guidelines in between April to June or July. Now, thereafter, she has been given in this order, even in this order which is under challenge, she is given liberty that you go and approve the tribunal. On last day, she came that I have some medical issues, so that has said that you go and approach the department, they will consider your representation. No representation has been made. She can go and made a representation to the department. Adequate reliefs have already been given to her. And in the meantime, this entire both this application can be decided by the CAT. We have already filed our reply. That is not.
What will CAT decide now?
But both this application, finally they can decide because our reply is in the records of CAT is not over here. That's filed, my
No,
lord.
but what will CAT decide? If she has already been relieved, then what will CAT decide?
But my lord, she is challenging a transfer order, which she can't, my lord. After 5 years,
No, that's a different point. You said that let both the affidavits be filed and then CAT will decide.
no, affidavits have already been filed.
Yes.
So
so
CAT
then
can decide this finally.
Suppose we say we will not interfere.
My lord.
All right. Then what will CAT decide? And in the meantime, she has been given her that relief order. Then what will CAT decide?
But she can give a representation till that time, my lord.
Till that time, what?
But I don't think they are going to expel her for that, my lord, because CAT has relieve her from her duty because CAT has already.
She has already been relieved.
No, relieve, my lord, it's in the nature of transfer, my lord. She has been transferred to Swarajdeep, so she can go and join over there. That is that order. My relief is not that we removed her from duty. They have only given effect to the transfer order, my lord.
The petitioner has seeks stay of an order passed by the tribunal on 31st January 2024 on an original application made by the petitioner against an order of transfer against an order of transfer dated that's 12 January. 12 January 2024. Order, no, this impugned order has been passed on which application?
Impugned order was passed in my application whereby I have been relieved, my lord.
12th
Very well.
January 2000.
Yes, no, what did I say? 31st January 2024, delete everything else. 31st January 2024, against an order passed by the Assistant Director within brackets admin, ADMN, close brackets, on 12th January 2024. Stop. The tribunal refused to pass a grant any interim protection to the petitioner. Stop. Next, the order from which the petitioner approached the tribunal, that is, the order dated 12th January 2024, is an order of release whereby the petitioner has been relieved from her post at GB Hospital, Port Blair, with effect from 31st January 2024. Stop. The petitioner, the order was passed on the petitioner's application against an order of transfer whereby the petitioner was to serve in Shahid Dweep. Shahid Dweep, just check the spelling, page 80. Shahid Dweep. On completion of her tenure at the place of posting at GB Hospital, Port Blair. Stop. Next, learned counsel appearing for the petitioner submits that the petitioners the order of release dated 12th January 2024 would render the petitioner's original application challenging the transfer policy of the administration, infractuous. Stop. Next, learned counsel appearing for the same paragraph, counsel submits that affidavits are already complete in that original application. Stop. Next, learned counsel appearing for the respondents submits that that there was no scope of interference against an order of transfer unless the same is found to be arbitrary. Stop. Next. On considering the material before us, it appears that the impugned order of the tribunal dated 31st January 2024, by which the tribunal refused to grant interim relief to the petitioner against the order of release, the tribunal has recorded that the petitioner intends to prefer her leave application before the competent authority capitals, and has given the petitioner liberty to do so. Stop. Next, we are also of the view that interfering with that granting any interim protection to the petitioner at this stage would amount to interference with the order of release, wherein the concerned authority has stated its reasons, which contains reasons for the order of release. Stop. We are not inclined to interfere with the order of release dated 12th January 2024 The order of the tribunal dated 31st January 2024 for the above reason, stop. We however deem it fit to keep the petitioner's challenge to the transfer policy open for consideration by the tribunal as and when the original application is heard out. Stop. Next, WPCT 14 of 2024 is accordingly dismissed for the above reasons.
My lord.
Yes, yes.
Mr. Kumar, how soon can your client join?
My lord,
Otherwise, you have been relieved from there.
my lord, transfer order is under challenge in another original application.
No, but Mr. Kumar, we will not give you that relief.
No, my lord, if my lord, if
No, you have said that you want to approach the competent authority to that. You always have that, and we will record.
till
that.
such time, my lord, at least the decision of the competent authority comes till such time, I shall not be disturbed. Otherwise, no purpose will be served.
Who is the competent authority?
Competent
DHS, my lord, DHS.
What
Depart-
cases?
The Department of Health.
director of
Director of
Health.
Health. But that is needless.
Till
to
such
say,
time,
that's
if
already
already
there in
there
class
is-
order.
Then it will be no, my lord, it is secretary, my lord. Respond number 3 is the competent.
Yes, how, no, how, otherwise you will be faced with discipline.
Yes, yes, yes. No, my lord.
How soon can you join?
No, my lord, what I told, my lord, since there is an order saying that I will approach the competent authority.
Then why have you come to here, to come to the court? Why have you not gone before the competent
My lord,
authority?
if I go to competent authority, unless and until I am protected, my lord, then in that case I have to join in the intervening period, then I will, it will be disciplinary proceeding and all this protection.
No,
It is
you,
not-
no, your client must join first. You tell us within how much time and we will record that so that you are at least not faced with disciplinary proceedings.
No, my lord, if I join, my
No,
lord.
Mr.
No, my lord, we will not appreciate the situation. The transfer order on merit is the subject matter of another original application. If my lord today pass an order not protecting my right, the transfer order.
If you succeed in that, Mr. Kumar, you come back from Shahid Deep
My lord,
to Port Blair.
my lord, it will be not possible, my lord, because my lord can be considered. I have challenged only the relief order. Transfer order is a subject matter of another original application. My learned friend says affidavit is filed. Let the tribunal take up the matter in the next week. Let the tribunal take up the matter in the next week.
No.
Can we consider this aspect, my lord? Transfer policy, no, very well. We will transfer order.
No, we will not give you that.
Yes, the tribunal is going on, let it be heard out in the next week, my lord. Till such time, some protection may be.
No protection. Yeah, we wanted to protect you in terms of discipline. You will not listen to us. Yes, we request the tribunal to consider the original application. Affidavits are complete in that.
My lord.
To consider the original application filed by the petitioner. And we request the tribunal to consider the original application. Tribunal is here till 16th. Next week, give us a date.
Monday, my lord.
In the coming week, preferably on 12th February 2024. Stop.
My lord, till such time, till no, my lord, kindly appreciate, my lord.
Till 12th. How will that help you?
My lord, 12th, the matter will be heard out. And the whatever order you
Leave on 31st January. Because we are already on 7.
My lord, immediately I approached this court. 31st January was the order, my lord. Immediately I came before this.
That will amount to interfering with the order of relief. We have given our observations.
My lord, I am just saying, my lord, heaven will not fall, my lord.
We give you that interim relief till 12th. How will that help you?
My lord, on 12th, the matter will be heard. And merit will be passed by the tribunal.
Mr. Kumar, kindly consider the concern of the patients. You have been relieved from GV Pant and you have not joined the transfer post. What will happen to the patients?
My lord,
Consider the anxiety.
transfer order, my lord, the transfer order is absolutely arbitrary order, my lord. That is the subject matter.
Tribunal, not here.
Once, my lord, I have been relieved, then transfer order would become effective, my lord. Kindly protect at least till 12th, my lord.
But that is needless to say, but that goes with the order of the care.
Very well, yes, call on the next matter, please. Yes, habeas corpus.
Supplementary list. Item number 1, WPH on of 2024.
But both the parties are over here, my lord.
Yes. Where is the petitioner?
My lord, petitioner is present. I'm appearing for the petitioner, madam.
The petitioner is not here.
No, here, Mary is calling one.
Please the petitioner, madam.
Yes, the pursuant to our direction, comma, the wife of the petitioner has been produced today in court by the concerned authority, by the SHO, by the SHO, comma, PS Aberdeen. Stop. The petitioner is also present before us. Stop. Which is the name? Yes. Where I've said wife, just say Miss, just give the name. Tiasa Biswas / Miss Aisha has been produced in. Next, nothing further remains of the writ petition. Stop. WPAH 1 of 2024 is accordingly disposed of in terms of the above.
I'll let me.
Yes, follow the next matter, please.
Item number 6. Academic on 2024.
The only point which is involved here is that whenever the court passes an order of remand,
Please address my learned colleague.
Your Lordship,
Yes.
whenever the court passes an order of remand, reasons have to be recorded. What is the reason of remanding the matter? There is neither any application under Order 41, Rule 27 by the other side, nor there was any prayer orally also for remand of the matter. So what was the reason? Up to the operative portion of the order, Your Lordship, the matter was in my favor. And in the operative portion, I find that the matter has been remanded. Kindly come to the order, Your Lordship. May I place, Your Lordship?
Yes.
Inner page 7, Your Lordship, of the appellate court's order. It's 19. Page number 19.
Yes, yes.
It is not out of place to mention that the plaintiff respondent herein has challenged the impugned deed of gift and stated that a fraud and misrepresentation was done over the executants of the gift deed. To some extent, it can be said the plaintiff has challenged the deed of gift. In this respect, on behalf of the plaintiff, an attesting witness has been examined
who stated that he signed a deed of gift at the registry office. Ashalata did not put her LTI on the deed of gift in his presence. Ranjit Biswas, Sanjeet Biswas and Kavita Biswas did not put their signature on the deed of gift in his presence. Therefore, it can be said that one of the attesting witness of the deed of gift says that the execution process was not done properly, and when the defendant's appellant herein failed to prove the deed in question by adducing evidence is a fault on his behalf. Omission to discharge any duty sometimes creates some confusion over the mind of the court. To overcome situation, the party who are in a position to discharge their legal obligation if failed, the court has nothing to do. Here in the instant case, it was a legal obligation of the defendants to examine the attesting witness of the deed in question, but that application was not discharged. Though referring one civil appeal, the learned advocate of the appellant stated that the defendants has no obligation to examine the attesting witness since there is no allegation of forgery or misrepresentation committed by them in respect to the deed in question. To
So
substantiate
the suit for partition.
suit for partition cancellation of gift deed.
Partition, the gift deed was challenged.
Yes.
What did the trial court say
Trial court said, Your Lordship, it has not been proved because as per.
with regard to the deed of gift
Yes,
and passed a preliminary decree for
yes,
partition?
yes. Now, Your Lordship, as per section 123 of the Transfer of Property Act, the gift deed has to be proved through one of the attesting witness.
Yes.
The respondent, Your Lordship.
There was no pair in the plain challenging the deed of gift.
It was there.
But the appeal court records there was no specific pair in the plaint regarding cancellation of the deed.
It was, my prayer was there, gift deed. The plaint is there, it is specifically mentioned, it is there in the,
Prayers have been quoted
it is.
anywhere in the. Or we do have the copy of the plaint.
I have. Just a minute, Your Lordship, it is there.
So evidence were not adduced with regard to this execution of the deed of gift.
No. I produced the attesting witness who said that execution did not.
Evidences were there.
Yes.
Evidences were adduced with regard to the deed of gift.
Yes. One of the
Any
attesting.
finding of the appellate court that evidence is not sufficient,
No. That is also not there.
but the appellate court records that.
That's why I don't understand how that recording is there when one attesting witness was already examined. Whether it was by the plaintiff or the defendant is immaterial. And as per section 123, only one witness is sufficient. It's not like will, where two witnesses, both the witnesses have to be examined.
Ashok,
And, Your Lordship, decision is there, Your Lordship, with me.
what decision?
Up to that point, Your Lordship, that the reasons have to be recorded and order 127 application is not there, then
The
the.
appellate court has to record that the evidence is insufficient. For
Insufficient.
that, it can be. Have you framed substantial question of law, though in remand, there is no necessity, but there is only one decision of, I think, of
Yes, yes, yes,
2005, which
yes.
says in an order of remand also the substantial
Yes,
question
yes,
of
Your
law.
Lordship. Page number 5.
I'm reframing the substantial
Yes,
question of law. Uh, This appeal is against an order of remand dated December 27, 2023, passed by the Learned District Judge in title appeal number 23 of 2022. First up, this appeal will be heard on the following substantial question of law. One, whether the Learned First Appellate Court was justified in remanding the matter to the trial court in the absence of any finding that evidence on record is not sufficient for arriving at a decision. This is the only
Yes, Your Lordship. Merit can't be entered.
issue usual notices. Call for the records. First up, the appellant shall, now, after arrival of the lower court records, the department shall examine the same and report as to whether the same is complete. First up, let notice of arrival, the department shall serve the notice of arrival of lower court records upon the learned advocate for the appellant. So the appellant shall prepare and file requisite number of informal paper books within a period of 4 weeks from the date of service of notice of the arrival of lower court records. First up, let notice of appeal be served upon the respondents. Respondent or respondents?
Respondents, Your Lordship.
Respondents. First up, liberty to mention after the appeal is made ready for hearing.
Obliged.
What is your ground number 4, Mrs. Nag?
You have not taken out any application, Mrs. Nag.
No, Your
So
Lordship.
after demand, it will proceed.
Yes, Your Lordship. No, Your Lordship, that adjournment petition I'll file, Your Lordship. Then,
Why adjournment?
Your Lordship, then it will be delayed, Your Lordship. Stay application, they will say
Yes.
file objection. So I will expedite this hearing of this appeal itself.
So unless there is stay, that will proceed.
No, once we are,
You cannot sail on two boats.
Your Lordship, once we are requesting the.
Or you can proceed before the trial court. Withdraw that this appeal, I think that will be better.
No, Your Lordship. I will,
How will this order help you, Mrs. Nag?
I will take out, if the learned trial court is taking up the matter,
Already that order of remand will be given effect to.
we'll be filing adjournment petition, Your Lordship. By that time, the matter will be disposed of here. Because the disposal of the civil matter takes time. Before that, the second appeal or the first miscellaneous appeal used to get disposed of. Lower court records are here only. Within a week, it will arrive. And I will file this paper book immediately.
Item number 7, Committee 5 of 2024.
I have interacted with the right ministry. And I sent a email around 2:58 PM
What is it? Have you got it or not?
I got a manual, my lord.
Manual?
I got a manual. This manual at para 1.5,
1.5.
my lord. The responsibility of the implementation of the program is vested with the national level. May I read, my lord?
Yes.
The responsibility of implementation of the program is vested with the national level in the Department of Elementary Education and Literacy, Ministry of Human Resources Development, Government of India. All the national level, at the national level, there is a general council, an executive committee, and a project approval board, PAB. The work relating to policy, appraisal plan, release of funds to the state implementation society, and overall review of the program of the technical support to the states, evaluation, supervision, monitoring, etc., by the Department of Elementary Education and Literacy. Next page, my lord, at 1.6. At the state level, the program is implemented in a mission mode by the state implementing society registered under the Societies Registration Act 1860, the General Council. This is, my lord, this is what there must be some society.
Microphone, please. Yes.
Well,
Microphone, please.
but there's a society which is of the local administration, if at all. Our responsibility is to finance and the program. This is all.
No, so if you say your responsibility is only to finance, then how does it help you?
My lord,
If you say.
say that the program, give the program that has to be executed.
Yes.
And for that we will have
For that, you will only give money.
money and technical assistance and all that.
What is the limit চাইছে? That has nothing to do with the project. It's to do with vacancy notification.
Mrs. Nag, this vacancy notice of payment, that has got nothing to do with this matter. You know what we are going to ask you? Yes, Your Lordship, because there was some confusion yesterday itself. I have gone through my petition. That advertisement has got nothing to do with this case. No, but, very well. Even if we accept your submission, what was your prayer? It was for regularization? Regularization. And for which post? MTS, multitask staffs in the education. Show us your prayer, please. Show us your prayer. In their respective post, but ground is there. I'll just show you, Lordship. Both the things I'll show. Prayer may be seen, Your Lordship, page number 23. A writ in the nature of mandamus directing the responder authorities to consider the case of the petitioners for regularization in their respective posts against which they are working for last more than 17 years, 13 years, 12 years respectively. What do you mean by respective posts? Your Lordship, some are project assistant. The names are different, nomenclature is different. They are non-teaching staff, but nomenclatures are different. And ground O may be seen, Your Lordship, ground O. For that, it is not the case of the authority. A specific project has been formulated by the Government of India and the petitioners are engaged to perform the work of the said project, and the petitioners are working in the block zonal office under Education Department of the Andaman and Nicobar Administration
and discharging the duties in the place of regular MTS employees.
MTS stands for what?
Multitask staffs.
Why Mrs. Nag, kindly come to page 262 of your application. This is your representation.
Yes, and you have referred to this tenth May
Vacancy notice.
2023 at paragraph 4. You have referred to that. Today you are saying it
I
is
have
not at all
referred, Your
relevant.
Lordship, but this is librarian grade 2. This is only one example was given by them, but they are not working. They can't be regularized as librarian grade 2.
No. This is not only librarian, for other posts also. As per the news item published.
These are all teaching staff posts. These petitioners are not working as under the teaching staff.
But
I
that
can
is
show
your
from the-
representation.
Is in representation, they
Which
have
is part
mentioned
of the
about
records.
it.
Paragraph 4 of that
Yes.
representation.
Yes. 16 May, you have referred to it, 10th May.
Request your good self to consider first our candidature as for regular post in the respective streams. That is a representation.
But those have got, that is
Then-
in the writ application.
Then you cannot press this representation.
I won't, Your Lordship, because there is some
Where
confusion
is your prayer
with
for,
respect to that.
where is your representation praying for regularization in terms of your prayer in the original application?
Not prayed for that, Your Lordship.
No. Did you make any representation for regularization?
About that representation, I have just mentioned, but I have not prayed that the representation should be disposed of.
No,
That is
not that. Did you? We are asking you whether have you made any representation in that regard, yes or no?
Yes, Your Lordship, this is the part of the
Where is
writ
that?
application.
Where is that representation?
This is that representation, Your Lordship.
This
There is no
says-
dispute to that fact.
This is with regard to vacancy notice. Mrs. Nag, if you don't press this representation,
But, Your Lordship, even if I am seeking for the regularization of my services in terms of that vacancy notice, I can't be regularized.
there are
Those
two,
posts,
regularization has to be in a post where you are presently working.
that only I have
So-
sought in the writ
So
petition,
that is one thing. So you are working under various in the respect of a project of SS Sarva Shiksha Abhiyan or so.
Your
but
Lordship, may
The
kindly.
vacancy notice speaks otherwise.
I have mentioned about the vacancy notice, but my prayer in the representation may be seen. I have not said that the post mentioned in the vacancy.
Everything is confusing. You have referred to that vacancy notice.
You have said 10th May 2023. Why
I
are you
have-
saying you are not referring?
No,
to the
Your Lordship, I
vacancy
have mentioned.
Then you
the
have to make a
representation
fresh representation.
in the this operative portion of my representation, the prayer.
notice? No.
Then
In
you
the
can make a
operative-
fresh representation. This representation is a very confusing one.
And Mrs. Nag, it will not go in your favor. Because if we have to do it, it is not that it is some discretion which we are exercising arbitrarily. We have to refer to your representation. Your representation refers to the vacancy notice of 10th May. The vacancy notice refers to posts in the administration, which are purely civil posts. All right. So once we come to those findings, then you will have to go to the tribunal.
Your Lordship, in any circumstances, the matter has to be decided, Your Lordship, because I was in the thinking that, Your Lordship, that
We will,
particular decision.
we are telling you, this is what we are going to decide, because these are the records in front of us. We can't decide, divorce the records. These are the records in front of us.
Yes, Your Lordship, even then, my claim is also in respect of a civil post under the education department. So there is no dispute to that, whether it is incorporated in the vacancy notice or whether it is with the department. My claim is in respect of those posts only.
No, but if you say that now, Mrs. Nag, then you will have to make a fresh representation, because your representation at page 262, that will go against you. In our finding that whether the High Court will have jurisdiction or the tribunal will have jurisdiction. As of now, we are fully of the view that you will be sent to the tribunal. And our finding has nothing to do with what Mr. Lal has produced today. Nothing to do with that at all.
With regard to your representation, reference to the representation which speaks about a vacancy notice.
Then in that case, Your Lordship, liberty may be granted. I will be filing the fresh representation before the authorities. That may be granted.
Before which
And then,
authority
Your
will
Lordship,
serve?
I will be deciding where to go and how to do.
And which authority will that be?
It's the
The,
Director of Education, Lieutenant Governor, the administration, Your Lordship,
no, page 262 is to the Chief
Chief
Secretary.
Secretary, Your Lordship. So basically, it is the Lieutenant Governor is the authority who frames the recruitment rule. So any kind of regularization has to be, the decision has to be taken.
But
by the
in any
Lieutenant
case,
Governor.
even if you file the vacancy notices of 10th May 2023, and nothing has been, no steps have been taken by them.
No, Your Lordship, they have taken the steps, Your Lordship. That's what I'm submitting. These people, they have incorrectly mentioned about that vacancy notice. They can't be regularized in this post where the vacancy notice has been published.
Yes, the,
But just one thing, just to show that this is not where just this case first came that tribunal has jurisdiction or not. This is not on whether the tribunal has jurisdiction or not, but in a Karnataka, manner, there's similar thing has happened where state is transferring this employees from SSA to state. So the case has been made up before that, thereafter it went to High Court and thereafter it went to Supreme Court. No mental issue has been raised in this matter. This is just to show this judgment has nothing to do with us. It's just to show that this.
Yeah, what to do with-
Went to Supreme.
why don't you give copies to your learned friends? I don't understand.
This case has nothing to do with this case. It's just to show that that in other states also CAT exercises its power in regard to SSA. There are hundreds of judgments of CAT upon SSA and recruitment rules as well.
Even I have the judgment of the Allahabad High Court,
Well,
where High Court has
High Court
exercised
exercise
jurisdiction.
both, CAT and High Court both exercise. I'm not denying this.
Very well, the. Manual on financial management and procurement issued by. No, the manual on, just delete the rest part, on Sarva Shiksha Abhiyan, check the spelling, of the Department of Elementary Education and Literacy, Ministry of Human Resource Development, is produced before us by Learned Council appearing for the Central, by Learned Council appearing for the Union of India. Stop. Next, after considering the representation made by the petitioners / staff of Samagro Shikha, ANN Islands on 11th May 2023, and the vacancy notification of vacancy notice issued by the Directorate of Education on 10th May 2023, we consider it fit to allow permit the petitioners, how many of you? The petitioners to make a fresh representation to the competent authority. For what do you want to, what did you, for regularization?
Yes, for regularization.
For regularization of the posts in which the petitioners, for the posts in Samagro Shikha, where the petitioners have been engaged for the last, how many years?
17 years.
17 years. Stop. The,
Or to frame job for job protection, Your Lordship. Because if
or to claim job
there is
protection.
scheme, for job protection.
or to pray for framing of a scheme for job protection for the petitioners. Stop. Next, the direction is based on our, on finding that, on finding a reference made to the vacancy notice in the representation dated 11th May 2023. Stop. Next,
Time frame.
yes, the competent authority, next paragraph, shall dispose of the representation, comma, if made by the petitioners, comma, within a period of
But it can be 4 weeks, madam.
we were thinking of giving you 1 week.
No, madam, because there are presidential visits in this
What?
island, madam. Presidential visits and all, madam.
Presidential,
President will visit this island, madam. So, madam. They'll be
yes,
engaged.
visit of the president, that's the way, you should say it. Within a period of, no, when is that? Today we are on 8th,
18th, madam.
today we are on 7th.
18th, madam, the visit is.
Yes, within a period of 3 weeks is fine. Within a period of 3 weeks from the date on which the representation is not there, so why are you worried? Let the representation first come. Within a period of 3 weeks from the date on which the representation is sent by the petitioners to the competent authority. Stop.
Obliged.
The issue of jurisdiction.
Yes, yes. The issue of jurisdiction of the tribunal to entertain the petitioner's grievance is left open. Stop. Matter number 5 of 2024 is disposed of in terms of the above.
First part. Dismiss for eventually.
Criminal appeal to have. Next week.
Item number 8. CLADB on a front category.
But I was to give my quick reply to whatever points Mr. Kapil and Mr. Bond raised.
Mr. Kabir, it says 8th February, the last order says 8th February. If you want, you can do it. We will treat it as on the days list. There's no point in keeping it
I
for
don't
tomorrow.
know, please.
Yes, sir. Yes. It was kept on 8 because of Mr. Tabriz.
Oh, that may be.
Well, no, but Mr. Tabriz had finished yesterday.
Yes, yes.
Yes,
Alright, so.
yes, we will, item number, this matter, just make it, this matter was kept, was to be listed tomorrow. Stop, however, comma, considering the stand taken on behalf of the parties, comma, the matter is to be proposed to hear the matter. Stop, the matter is to be treated as on the days list. Yes, with the consent of the parties. And Mr. Kumar had also finished.
Yes.
Yes, yes, Mr. Kabir.
Manu, there are 4 points which need to be addressed. The first is with regard to the PW9 angle. Very simply, Mr. Tabriz and Mr. Binu had a master stroke by coming to the High Court and obtaining an order with regard to PW9, saying that he needs to be cross-examined by the
CRR.
in the
Yes, ma'am.
CR. The reason for that is 145 of the Evidence Act is clear that in any event, cross-examination will take place. Whether the High Court's order was there or not, the IO would have been cross-examined. The reason it became relevant is because the IO was not produced. So today, let us assume the High Court's order was there or not. If the IO was examined, PW9 would stand or fall. If the IO was not examined, PW9 would stand or fall. It made no difference. The reason I'm saying this is today, let us assume the IO is examined over a video conference or whatever. It will clarify the situation with regard to PW9, but it will not change anything in the complexion of the case. To this extent, if the court pleases, then the powers are there to examine the IO. That can be done even now. Assuming that the court says, we do not want to go into this entire question of the IO, we do not want to enter into PW9, let's discard PW9 altogether. The eyewitness goes, the circumstances remain. That aspect of the case has not been considered.
So discarding PW9 is what the first court has done anyway.
Yes, so that's what I'm saying. Let us assume today that PW9 is to be discarded. Even assuming he is being discarded, it doesn't change anything in the circumstantial evidence. That's the first thing. The second thing is Selvi. Mr. Tabriz was talking about how Selvi has not been complied with. Selvi was delivered on the 5th of May 2010. The consent in this case was given on the 16th of October 2007, 3 years before Selvi. Selvi's guidelines didn't exist, number one. However, there were two other Supreme Court judgments. One is 1955, probably Katikalu Ogad, and the other was Nondili Shakpati. Both of them dealt with 20 clause 3 testimonial compulsion and the aspect of a medical test which your body betrays you to make a statement. Those guidelines were fully followed. The guideline is very simple. The person is to be made aware that this test is to be done and that person is to give his consent. If your lordship see the records, in writing, consent was given and recorded before the magistrate. So the question of consent being something which they didn't understand, they didn't want to do it, these are completely academic questions. If they had to withdraw consent, they could have done so at any point of time. That also was not done. So today to say that consent has a question mark hovering over it, absolutely does not lie in the mouth of the accused. Third thing, the aspect of misdirection, which is something very vital because it shows the conduct of the accused. First of all, I have shown the GD entries. Now, my learned friend said that the GD entries are not very material because they only show people coming, going, things like that. Well, there was no need for them to say anything. The very fact that they said something which was not the accurate picture indicates clearly that there was an attempt at misdirection. Along with that, if you also should just have the record for a moment. Since we didn't have the benefit of the IO to cross-examine him on all these things, just see the record for a moment, the B file.
P5.
B file, the file before the magistrate. I have flagged that relevant document. This is part of the judicial record. There's a fluorescent yellow flag on it.
Yellow.
The yellow flag. These were the sanction orders issued by the administration and submitted before the court based on which the persons were prosecuted because they were police officers. Kindly see paragraphs 8, 9, 10, 11. Now this document is given to the court by a fairly senior police officer of the IPS. This describes the confusion under which the police were laboring because of the fact that these two officers, A, did not make a proper GD entry, B, they made a GD entry saying something totally different. So when my learned friends say that there was no misdirection, there was no confusion, that is not entirely accurate. This was the actual state of affairs which was informed to the court. That is why they went for that narco analysis and everything else, because they had two sets of suspects and one set had acted suspiciously, which were the police officers. The other set were not reliable because they were civilians. So that was the aspect of the misdirection. So it is very, very clear from their conduct that even the police officers themselves felt that these two accused persons were not acting properly and that there was an attempt to throw off the case. That is in addition to the fact that I've shown the GD entries. The fourth point, which Mr. Tabriz had emphasized on, was with regard to the fact that Rajesh was picked up and these people were picked up, and that a challan case was created. And in fact, the learned PP had spoken about how the learned PP had spoken about how if a police officer had been assaulted, there should have been a separate FIR. But let me make it very clear. 34 of the Police Act, if your lordship sees for a moment, because that was the offence with which that man was challan. The challan is at page 133, the GD. 134 is the relevant page. 134, the top row, 4 lines from the bottom.
Yes.
A challan under section 34(6)(p) Act was registered separately against the accused. Will be produced before the court. Now, this 34(6)(p) Act I was having difficulty with, but I found it. This is the Police Act of 1861. Section 34 deals with punishment for certain offences on roads, etc. Any person who on any road, and in any open place or street or thoroughfare within the limits of any town to which this section shall be extended, commits any of the following offences to the obstruction, inconvenience, annoyance, risk, danger, and damage of residents or passengers, shall on conviction before a magistrate be liable to a fine not exceeding 50 rupees or to imprisonment with or without hard labour not exceeding 8 days. And the sixth clause is, being found drunk or riotous. Any person who is found drunk or riotous or is incapable of taking care of himself. There was no whisper about this entire incident that a police officer had been pushed down, that there was some sort of an altercation, nothing. It was only with regard to this one person who was picked up and this one person who is shown, Rajesh, who is shown to be drunk on the road. That was all that the accused persons said. The reason was they did not want an intense scrutiny of what had happened there last night. And that again shows their conduct. Immediately after the offence, returning back to the police station, the way in which they behaved. They gave this man a challan for being drunk on the road. That's it. And this is what is reflected in the prosecution sanction orders as well. This was what their conduct indicated they were trying to conceal. There was no need to conceal that incident. And that is what sheds an additional circumstance by virtue of Section 8 of the Evidence Act. These are my 4 replies to the points raised by Mr. Tabriz.
Thank you.
My lord, may I take 1 minute, my lord?
Yes.
My lord, my learned friend says, my lord, the criminal trial has to be proved on the basis of oral and documentary testimony adduced before the trial court. PW8, PW12 and PW13 categorically stated that on the date of incident they went and they informed. PW13 is the SHO. You categorically stated that the nuisance were created, this and all. So that evidence is there. So that part which my learned friend says, there is cogent evidence. PW8, 12 and 13 says they informed. This is first. Second, my lord, the order of the High Court was that once the IO comes, we get an opportunity to contradict the statement which was made by him before the trial court and the 161 statement, because he projected himself as eyewitness during the trial, whereas his statement was recorded after 2 days. He stated only that he went for fishing on that day, if my lord sees, and that's why the PW9 was important. And thirdly, my lord, the concern my learned friend submitted that there was a written consent. There was no written consent, my lord. There is an order of the court wherein the signature of this accused persons and the other 2 persons reflect. That is there in the lower court record. Therefore, my lord, these all arguments are contrary to the.
Thank you. Mr. Kabir, Mr. Kumar, when will you give, Mr. Mohammed also, when will you give your notes?
I have already given.
I have already given. You have already given?
Yes.
Also, Secretary may also be.
Sorry?
As my case. That's the
নোটস গুলো দেখো তো আজকে
मैं हम making a link here as exponents करें हम ना रखी ना जिसको भेजा था
Appellant. Kabir.
There will be a separate sheet with the list of the names.
Mr. Kumar is for Mr. Howlagar.
Malad.
No, but what about,
No, we have given jointly, my lord. We have given
Jointly?
for respondents, yes.
no, and Mr. Tabrez was appearing for?
And Jose.
Very well. We will keep this matter one day, probably next week, and then make it reserved for judgment.
Hmm.
Or maybe keep it to Friday. भी रखा करेगा. Yes, learned counsel for the parties have concluded their submissions. Stop, list this matter, the notes. Council have also filed their respective notes. Stop. Next, list this matter on 9th February 2024.
Obliging.
Yes, we will sit around 1:25. None of you wear watches.
My lord, here I would like to mention one matter, my lord. I would like to move
Yes.
one unlisted motion, my lord. There is an extreme urgency because, my lord, the Tehsildar has passed an order wherein tomorrow 10 o'clock is the date for removing me from the occupation. So there is an extreme urgency, my
No,
lord.
when did you get the notice of that?
My lord, order has received on Monday, my lord.
Monday?
The petitioner is the resident of Sarasdeep.
No, that's all right, but when did you get the order? Or
On Monday, my lord.
Monday?
Monday. And the date is fixed tomorrow, my lord. In the order it is mentioned, my lord. The appeal is already pending before the Lieutenant Governor, my lord. The
And
appeal is already,
who is the respondent in your petition?
usually, Mr. Shivabalan appears, my lord.
Mrs. Sivabalan, can I keep the matter at 2:30? Give him a copy of the writ petition.
Oblige, my lord. Leave may be granted to file them.
Yes, at a supplementary list per kotha.
Oblige, my lord.
Yes.
My lord, may I mention one more matter, my lord?
Yes.
Here, my lord, the my lord had passed an order on 1st of February, my lord,
Yes.
wherein my order has been set aside by this honorable court, but the re-hearing was given, my lord. Opportunity was given,
Yes.
but the time was not mentioned, my lord, in the order.
Yes, show me the order, please.
This is the order, my lord. On first, the order has been passed. That's- Wherein the second page, the authority shall give a fresh hearing to the petitioner and other relevant parties under upon considering such documents, including the decision passed by the coordinator. But there is no time limit,
Yes,
my
to
lord.
mention tomorrow.
My lord.
And notice to the other side, please.
My lord. Yes. Oblige. my lord.
Item number one, WPA 103 of 2024.
Which one? Yeah. Yes, yes.
My lord, I am for the petitioner, my lord. It's a matter of electricity connection, my lord.
Yes, where's your representation?
My petition, page number 10, my lord.
Page number 10.
My lord.
Yes.
I'm
Yes.
not paying the respondent. It can be discussed.
Yes, same order as passed yesterday, except 21st November is the 21st November 2023. Disposed of.
Obliged, my lord.
Within 3 weeks. Within 2 weeks, 2 weeks, 2 weeks.
Item number two, WPA 108 of 2024.
My lord, I am appearing on the behalf of the petitioner, my lord. My lord, I am appearing on behalf of the petitioner. It's an electricity matter, my lord.
Yes. 24th January.
Yes, ma'am.
Yes, my lord.
Three weeks. 24th January 2024.
Deeply obliged, my lord.
Three, 2023.
Lordship, in this matter, I am for the petitioner.
I can't hear you. Microphone, please.
I am for the petitioner, Lordship. The petitioner has filed the writ petition challenging the order passed by the Tehsildar Port Blair, Lordship, wherein the Tehsildar Port Blair is to evict me from the
Microphone, please.
premises, Your Lordship, under section 161, Your Lordship. Your Lordship, my submission is that, Your Lordship,
Section 161, no?
Andaman and Nicobar land.
Complete your sentence, please. Yes.
My submission is twofold, Your Lordship. The private respondent, Your Lordship, has suppressing the material facts, obtained certain orders from this Hon'ble court. And
Who is talking in court? Yes.
suppressing the material facts, obtained certain order from behind my back, obtained certain order from this Hon'ble court, and a direction upon the Tehsildar concern, upon that the Tehsildar for this order, Your Lordship. So, Lordship, the facts of the case is that, Your Lordship.
No, where is the order?
Order is at page 70.
70?
Four, Your Lordship.
Four.
Your Lordship. The brief facts of the case is that, Your Lordship.
74 is not the order, please. It's 75. Yes. No, what is the basis of challenge? Hurry up.
Your Lordship, the order which has been passed by the Tehsil concern, Your Lordship, on the basis of the writ petition, order passing the writ petition, Lordship. In that writ petition, I was not made as party, Your Lordship.
Where is that writ petition? One more question, I am going to dismiss this writ petition. Place your facts properly, please.
Lordship, the facts is that, Your Lordship, the private respondent herein made a complaint in the year 2000, Lordship, that I have encroached a certain piece of land
Yes.
of the private respondent, Lordship. As such, he made a application of section 161 of Andaman and Nicobar Island Regulation, Lordship. That in that order, in that petition, Lordship, the Tehsildar concerned passed an order directing me to that eviction order was passed, directing me to evict from the said portion of the land, Your Lordship. That order was challenged by me before the SDO, Lordship. The SDO concern upheld the order, whereafter the order was challenged before the Secretary of Revenue. Before the Secretary of the Lordship, the Secretary of Revenue remanded back the said RC, Your Lordship, with that case before the Tehsil concern on the ground, Your Lordship, that the report which has been filed by the surveyor, Your Lordship, in that the period of pollution, Your Lordship, has been mentioned 8 years. It has been some handwritten correction is there. I have said that has to be verified, and further the 90 days of time was given to the Tehsildar concern to ascertain whether the said occupation will come under 161 or not, Your Lordship. But whereafter, Your Lordship, this private respondent did not challenge that said order. This private respondent came before the Hon'ble court, Your Lordship, by filing a writ petition in the year 2005, Your Lordship. This and that is annexed at page 32, Your Lordship. In the writ petition, Your Lordship, the Hon'ble court pleased to modify the order only to the effect that, Your Lordship, the period of 30 days was curtailed, 90 days was curtailed to 30 days, Your Lordship. Thereafter, the said RC case was not proceeded with, Your Lordship. This private respondent filed a civil suit. After a lapse of, Your Lordship, more than
The facts cannot be a basis of challenge to the order. What is the legal basis?
I'm coming to that, Your Lordship. I'm coming to that, Your Lordship. Now, Your Lordship, kindly appreciate that RC case was initiated being number 473 of 2000, Lordship. Thereafter, these private respondents filed a civil suit challenging the title suit, Your Lordship. That title suit was dismissed. I appeared in that title suit, filed a written statement that was dismissed in the 2013 for non-prosecution by the private respondent, Your Lordship. Now, in the year 2018, Your Lordship, these private respondents again made an application under 161, stating that he has been evicted, Your Lordship. That application.
I thought you are the one who's been evicted. Now, private respondent.
I have moved to Lordship.
Just now you said private. Filed the RC.
I was again yes, my Lordship. That the first RC case, Your Lordship, he did not.
Yes, 1 minute. Yes, Mr. Sivabalan.
Lordship, in this case, I will come back with the instruction. I have not been given the copy.
Not served.
Not
Of the department, Your Lordship, long back, Your Lordship. If my learner wants to have served, Your Lordship.
Yes, list this matter tomorrow as paid for on behalf of the respondent. And please give me in one page your grounds for challenging the.
Yes, Your Lordship. Yes,
Tomorrow.
yes, Your Lordship.
Oblige, Your Lord.
Item number 5, WP 11 of identical.
I'll just give you my copy also.
Notes of argument. Yes. It's only 2-3 pages. Copy of the judgments.
Anjali Madam.
Copy of judgments. Judgment which you relied on yesterday.
Yes.
Or no, or new judgments.
A new judgment is there.
Why have you given new judgment? Then you have to place it.
Yesterday I felt I got one good judgment, you know, apt to the point, so I have it. I've given the citation to the other side.
Manoj,
This is for Mr. Kabir.
my lord, I have given mine, there are two enclosures because
And what is this?
my lord, the two enclosures because I've made statements, I've not filed an affidavit, so I wanted to show the record so that the court could rely safely on my submissions.
No, 1 minute. Then I will have to hear Mrs. Nath first.
My
Yes, Mrs. Nath, which is this new judgment?
Your Lordship, new judgment is this Gulf Goans Hotels Company Limited and other. There it has been held
STA
that
का एक
any
है.
guidelines
Let me find the citation.
I'll give you the copies.
Doesn't have an SCC citation. Yes, 2014 10 SCC. Yes.
Yes. Your Lordship, it's, my opinion is that it is apt to the point, Your Lordship. Because what the
I've
authority,
forgotten the point. Now tell me how is up to the point.
the authorities have been saying that the recommendation which has been made by the STA, that recommendation is for the benefit of the local candidates of these islands. That is their basic thing. Now, Your Lordship, here also in this case, the authorities were saying that what decision they have taken, some guidelines they have framed, it is for the ecology, for the development and for the protection of ecology. That was their concern. The Honorable Supreme Court has said that whatever you make, you have to adhere to the provision of law. Either the Act, Environment and Forest Act, or under Article 77, you have to publish a notification. Without that, you can't do it.
Which paragraphs?
Your Lordship, it's paragraph 14, 16 and 21.
You're not mentioning the articles of the Constitution. Or
Article 77 of the Constitution of India.
Twenty-one is what? Guidelines. Which guidelines did the Supreme Court say that they have to follow?
Your Lordship, guidelines, what the authorities have framed to protect the paragraph. Yes, paragraph 15 may be seen. Article 77 of the Constitution provides the form in which executive must make and authenticate its orders and decisions. Clause 1 of Article 77 provides that all executive action of the government must be expressed to be taken in the name of the President. The celebrated author H.N. Servai in Constitutional Law of India, 4th edition, volume this, describes the consequences of government orders and instructions not being in accordance with the clause 1 or 2 of Article 77 by opining that the same would deprive of the orders of the immunity conferred by the aforesaid clauses, and they may be open to challenge the ground that they have not been made or under the authority of the President, in which case the burden would be on the government to show that they were in fact so made. In the present case, the said burden has not been discharged in any manner whatsoever. The decision in this para 17 taking a somewhat different view can perhaps be explained by the fact that in the said case, the interim directions contained in the government letter was in exercise of statutory power under section 34 of the Air Corporation Act 1953. In the present case, the interim guidelines under any existing statute. My submission is,
And in this case, the case before what you're showing, The guidelines were issued how? In what form?
In the form of a letter, in the form of a, what to say, just a minute. A document, I can say. Just a guideline was issued, that's it. The, just a minute. This is at paragraph 4. Your Lordship, paragraph 4, down portion may be seen. The power to give effect to the guidelines and to penalize violate, however, just a minute. Yes, however, with the enactment of Environment Protection Act 1956, with effect from 19 November 1986, section 3 and 5 empower the central government to pass necessary orders and issue directions which are penal in nature. It is in exercise of the said power under Act, what with the guidelines referred to above, that the orders implemented by documents have been passed. Though the Coastal Regulation Zone Notification of Act was issued on 19th February 1991, and it admittedly is prospective in nature till such time, the said notification came into force. It is the guidelines which held the field, the administrative instructions having the effect of law under Article 73 of the Constitution. There were certain restrictions imposed through the guideline to visit the beach.
Very well. So the guidelines were issued how? Just
by issuing orders, Your Lordship, in that manner. The order was issued.
yes, but here the general provision of Article 77 was held to be whatever of the Constitution, but there must be a manner in which executive action is done or is articulated. But what is the specific? Like you're saying that Rule 50 or whatever it was, but there is nothing.
Nothing. Here also, there was some power given to the central government to issue executive instructions. But that was not exactly in terms of the statute, as in my case. It is not that state transport authority has been given the authority to frame guidelines in the said manner or something to do with that. State transport authority has not been given that power at all. So that authority is issuing. Basically, I am challenging the authority also. Even if we are stretching it to the extent that I was arguing yesterday that no approval has been granted because they were not able to show any approval of the president or of the lieutenant governor also. They have not shown it. Let us assume, Your Lordship, it was passed under the instructions of the lieutenant governor. Then again, one judgment is there, Your Lordship, that lieutenant governor cannot step into the shoes of the president unless and until specific delegation is there.
Yes.
So, and moreover,
That central government means the president, that one.
yes.
Yes.
Moreover, Your Lordship, this judgment is far better, Your Lordship, where there was a power also. The court said that under the statute, you have not been directed to do a particular specific thing, but you did it. If you are doing it, then Article 77 has to be followed. That way I am linking.
Very well. That is the only decision you want to cite.
The other one, Your Lordship, already yesterday I have
Which one?
this
Vadera.
whatever.
Which paragraph? You have already cited yesterday.
Yes, 27, paragraph 27.
27.
No, I'm sorry, 34, paragraph 30. So see, here, this judgment I have enclosed, Your Lordship, to show that even a rule cannot act contrary to the act. Even here the guidelines are there.
Yes.
But the court has held that if any rule is there, rule-making power was there with the lieutenant governor. Even if rule is framed, which is not in consonance or contrary to the act, that cannot be accepted. And it cannot be given effect.
And which is the provision which is contrary to the act? Which rule is contrary to which section?
The guidelines, Your Lordship, imposing restriction for issuance of license.
Give me the page, please.
Yes. What Yes. The State Transport Authority, what they have done, they have decided that only license will be issued to the local candidate. And also, that also, I remember your submission, just show me that additional condition. Yes, additional condition. You're leaving the court, Mrs. Nam. I'm bringing the file. That is in the case of Mr. Binu Kumari. Yes, yes. WP 11 or 24. Yes. Page number first is just. 21. First is 21, page number 21, 2007. WPA 11, page 21 is the grounds, are the grounds.
No, vacating application.
Vacating application.
Vacating application.
Can
21. Yes. Now, your lordship may kindly sit down. Yes. Eligibility criteria for inter-district tourist permit, auto rickshaw permit in South Andaman. Yes. Permit will be issued only to the local employed below 40 years of age. Yes. Then certain conditions have been imposed, your lordship. It is in respect of that clause 1 itself. That is, should submit islander identity card or local certificate. Now, if we compare it to the not clause 1, this is clause 2. Eligibility criteria, this is clause 2, and which is the one we are agreed by? 2I, your lordship. 2I. So that is 40 years. You know, it will be issued only to the local employed people. Unemployed people. Below 40 years of age. Yes. Then the other conditions actually follow 1. Because they say that vehicle should be owned by the applicant, should submit her own driving license, should submit islander identity card or local certificate, all these things. Now, with regard to permit, the chapter has to be seen. That particular chapter under the Motor Vehicles Act prescribes that what are the conditions on the basis of which permit can be issued. Yes. It does not include all these things. How can it be incorporated in a meeting? So you're relying on chapter? Yes, chapter is just a minute. The chapter concept. No, let me put this all this in your note. Your lordship, I have mentioned about that. Chapter, just a minute. Yes, chapter 5, page number 68. Section 68, I'm sorry. No, you haven't mentioned section 68. 66, I'm sorry, 66. 66, it is relating to necessary for permits and all conditions are mentioned. Yes. Very well. So that is your point, that the considerations which, or the concerns which Mr. Kabir raised and Mr. Chakraborty, that all that can only, that is the second stage. The first stage is that whatever rule you are making has to be in terms of the Act, Motor Vehicles Act, and next has to be in terms of the rule making authority which you have. Yes. Which is Rule 50. Yes. According to you. Yes. And the prescribed word is that in terms of the rules. Not that what Lieutenant Governor is prescribing or what the STA is prescribing, not that. It should be in terms of the rules. Now, whether the rule says that these conditions can be incorporated. Rules does not say so. Yes, very good. That is all. Thank you. Yes. Yes. Similar thing is there in the other guidelines, Your Lordship, because there are 4 to 5 orders have been passed by the FTA in different meetings. So have you said that in your note? Which page? No, I have not mentioned. No. How will I know? That which orders are under challenge? I thought it's only one. I have mentioned about the dates. Page number I have not mentioned.
It's there in my notes, man.
But I will have to locate the document.
Just correct.
I was only showing you page 21 of the vacating application.
I will just mention in my,
Yes, sir, do it right now. Yes. I will have to locate, see the document.
yes.
Because it's a composite note.
Yes.
So I have to see what documents are on it.
21, 24, 94, 106, 116. 5 of them.
Yes, Mr. Kabir.
Now, but I have submitted my note. I have dealt with the issues separately.
So this is on your behalf as well as Chakraborty.
No, Mr. Chakraborty has already submitted before he left. This is on my behalf.
Chakraborty को note है Yes.
27/3/2018
Yes.
So I have broken it into issues and dealt with the issues separately.
Yes.
So for example, at page 2, your lordship will get what your lordship was looking for. The decisions which are under challenge, although with the greatest of respect, I don't find the writ petition to be challenging this.
27 September 2018.
The writ petition is challenging a condition without very specifically challenging any of the decisions or the policies or the virus or anything. Even the writ that is sought for in the nature of mandamus is directing the respondents to act strictly in terms of the Motor Vehicles Act, to rescind the show cause notices and to withdraw the conditions. But it doesn't challenge any of these things of the virus error. Anyway, now, first of all, the conditions that my learned friend is talking about, those conditions are not restricted only to the first one. If your lordship has a look at page 21 again, that will be clear. The first condition is that it will be issued only to a local unemployed person.
Yes.
That agrees them. The vehicle should be owned by the applicant, which fits in with what I said, that it's not transferable under the Motor Vehicles Act. That will agree them because they want others to be allowed to drive it. Should submit islander identity card, local certificate will agree with them. And number 6, more than anything else, then not more than one permit to be issued to one person, which is all in the scheme of what I had submitted yesterday. Now, I had made some submissions yesterday, but I have not filed an affidavit, so the documents are not there, just so that I'm not just, my words are not just blowing in the wind. I wanted to show the record to your lordship very briefly. I have mentioned them in my note, but these are the documents.
So you've handed up something as well.
The note.
No, according, so with the notes.
No.
The
First of all is a letter dated 3rd July. The letter dated 3rd July is a reflection of my submission. I have told your lordships that these criteria have remained the same over the years. The trigger was the enforcement. Now we have obtained this letter through RTI. This letter explains exactly that the State Transport Authority has been receiving complaints on violations of permit conditions by vehicle owners and drivers, especially auto rickshaws. It was not targeted at them, it was in general. So the traffic police were doubted to take stringent action. It was therefore requested to conduct a special enforcement drive to check any kind of violation and to take stringent action against violators, and action taken report may be furnished. So what had happened was they were doing a general traffic police checking for anything, for talking on the phone, wearing seatbelts, everything. It was in part of that this came to light, that the person who's not the permit holder is driving the auto, which violates the conditions, and hence all this has started. That aggrieves them. That the question of change in the policy doesn't rise. So this demonstrates what I had said. The second thing is I had talked about the categorization of people in the islands. So the second document, the reason I've relied on this is it's a circular of 2016. That's not the first part is not so relevant. The third page onwards is relevant. You gave your copy? This gives the historical background that I was submitting yesterday.
Third page is not paginated anyway.
No, just the third page, guidelines for enrollment.
Yes.
The background, first of all, from 1986 onwards, there was a policy decision to work out the population in the Andaman Islands and the carrying capacity, and identity cards were being issued. The third paragraph there talks about how in 1992 the concept of islander identity card came up. And what I submitted is on the next page, the Shekhar Singh Commission
Yes.
Now here, the Shekhar Singh Commission was set up with regard to environmental issues, but it had reported to the Supreme Court, and one of the report recommendations was with regard to the islander identity cards and classification of the islanders. On the basis of that, there was a direction from the Supreme Court on the 7th of May 2002, directing issuance of the islander cards in accordance with the classification. I have given at the back that order of the Supreme Court as well. It's a daily order, so it's not in a very clear format, but the direction is there. Again, I'm sorry, now it's not paginated. Now, what we'll see in the Supreme Court's order, various recommendations have been considered and directions were issued. The direction in question here first of all was 13 with regard to identifying families with regard to forest land and things of that sort. 14 was with regard to eviction of people. Now, all of this culminates in direction number 17. The whole point was to identify the different categories of people at different times who've come and are staying here. But that was in context of forest encroachments.
Identity cards to be completed within
a period of 6 months. On the basis of that, and on the basis of the Shekhar Singh Commission report, those old MHA classifications were being taken and islander cards were being issued. This is the legal background.
MHA?
Ministry of Home Affairs.
Yes.
This is the legal background in which this whole concept came up. Now, as I said, this was tested by the Honorable Supreme Court. This is the judgment, Parents Association. Now, these guidelines have mainly been questioned in areas relating to education, quotas in education institutions, and also public employment, but they are equally well settled in this.
But the guidelines were issued much later.
No, the guidelines originally came in 1984.
Yes, 7/5/2002.
And
The one-
75 is a direction of the Supreme Court only.
Yes.
The Ministry of Home Affairs guidelines came much before that. If your worships take the judgment, paragraph 2. Paragraph 2 talks about the challenge that was there against the different Ministry of Home Affairs proceedings. The first was of 1984, 14th February, then 4th of September 1991, and finally 30th of May 1996. The one currently in force is 30th May 1996. This was the one which talked about allotments of seats based on the categorizations. And there at the last 5 lines of the paragraph, the officers will find what was the discussion with regard to keeping it in conformity with Articles 14, 15, 16 to redefine local and permanent resident by removing all discrimination on the basis of race, descent, place of birth, etc., to divide the entire community of school-leaving students and permanent residents into 2 categories, tribals and others, subject to the condition they have studied for 10 years, passed qualifying examination, etc. Thereafter, paragraph 3 talks about exactly the classification, that there are several categories of persons residing, tribals, pre-42 settlers, post-42 rehabilitation scheme settlers. Then 4 is those who have come to the islands for business and professional purposes and have put in 10 years education. Thereafter, it talks about how the quotas have been done. On the next page, paragraph 7 will describe how these different classifications evolved over the years and the quotas were made. Now, I'm not for a moment saying that these are with regard to auto rickshaws and motor vehicles. They are primarily for classifying people as to what benefits they get. But this logic holds equally good in the sense of the submission that when there is an intelligible criteria which is already created, it has sense here and it has a nexus with what is being done. This judgment is a detailed judgment which examined these and ultimately came to the conclusion that these sort of classifications in the Andaman Islands were justified and has upheld them. And we have been following these. In fact, ironically, Ms. Nag has contributed a lot to these because she used to fight these cases at that time. And now this has become the established law. So this is our own creation.
There again, the guidelines are there by the MHA.
Yes, but now the Supreme Court has upheld it, so. Now,
There is no estoppel against appearance.
now, so far as the powers are concerned of the State Transport Authority, like Ms. Nag has placed today that Gulf goings matter, I was looking for something closer to home. And I found something which may help us.
As in compared to Goa.
Yes, I'll definitely come back. I'm copying it. This is 2014 3 CHN Calcutta 227. Justice Doctor had occasion to consider decisions of the RTAs with regard to auto rickshaw route permits. Now, while it's obviously not the same thing as we are dealing with, there was essentially a notification of the state government empowering the state transport authorities to take decisions on how permits are to be put in place and the conditions. And the third page, Your Lordship would find, after the notification was issued, the state transport authorities in the transport department had taken a decision that they would issue page 3.
Yes,
They would issue these 6 conditions
yes.
for auto rickshaw permits. And the challenge was leveled on 2 grounds. The first was that the notification is ultra vires of Motor Vehicles Act, because the Motor Vehicles Act doesn't give these conditions, so how can you give these conditions? And the second was the decision-making power of the state transport authorities, whether they were empowered to just take decisions like this and have a guideline which is not notified and is not a actual legislative action. Now, if Your Lordships come straight away here to paragraph 14, Your Lordship would find those 2 questions being framed by the bench. Having heard the parties at length, the first question that the court is called upon to answer is whether the notification dated so-and-so is valid in the eye of law or not. Should the answer be in the negative, it is declared ultra vires. The impugned resolutions of the respective RTAs rejecting applications for permits are likely to fall through. Now, in West Bengal, there was a notification empowering the STAs to take decisions. Here, there are the rules which are notified in 2006, which equally empower the STAs as part of the conduct of their business to make bylaws if they wish, or to take other actions, decisions. Now here, this particular power of the RTA has, in fact, is pari-materia between West Bengal and here. Compare the West Bengal rules with the ones here. Paragraph 15, the court discusses how this has to be tested on the touchstone of the Constitution. What is important is 16, which describes how the Motor Vehicles Act then is read into the motor vehicles rules in West Bengal as well as the Motor Vehicles Tax Act in West Bengal, and how these different permits and the conditions are imposed. Paragraph 17 frames the question specifically that we are actually dealing with. Now, if a statute or subordinate legislation does not provide any guideline, either in skeleton form or in great detail, how a particular situation is to be dealt with, and there appears to be a vacuum, what is expected of the appropriate government to deal with such situation? Then there's a discussion on the law starting from Tendulkar. The court invokes the powers with regard to Article 162, executive directions of the state, and creates the proposition that the executive powers are obviously coextensive with the legislative powers. So the court creates what I would humbly say is a legal fiction, that the actions that are being taken by the STA in taking these decisions, the minutes and all are merely the form in which they are represented. Whether it's a minute or a notification or a guideline is just semantics. It is a decision that is taken, which is the actual thing to be studied. Now, the decision that is discussed here, the court creates this fiction of saying it is a quasi-legislative executive action. Because there is a power flowing to make rules, make laws, impose other conditions that you wish, therefore it is quasi-legislative. But because you don't actually have legislative powers, it is an executive fate which can be read into Article 162. If Your Lordship sees, after a discussion of the law, 26, paragraph 26, 25 and 26, what emerges from the above is that even if there exists a central legislation providing eligibility criteria, the source whereof is an entry in list 3 of the 7th schedule, it would nevertheless be open to the state government to issue executive instructions providing eligibility criteria in addition to those fixed by such central legislation, which are not contrary to the public policy or the object that the statute seeks to achieve, and which are definitely in public interest. Averting attention to the MV Act and the WMV rules framed thereunder, it is found that the guidelines for grant of permits to operate auto rickshaws are few and far between. The MB Act as noticed above goes no further except section 73 and 74 in relation to the procedure for grant of contract carriage permits. 95 and 96 of the MB Act authorize the state government to frame rules for carrying out the purposes of the chapter in pursuance whereof the WBMB rules have been framed. Rule 88 of the WMB rules confer power on the STA to frame policies to control and coordinate the matter of road transport subject to directions issued by the state government and sub-rule 4 of Rule 120 thereof. This is exactly what I'm talking about, is pari-materia to the powers in Rule 50 here. Thereafter, the court considers with regard to the powers of the STA to frame policy, paragraph 27. These are the statutory provisions operating in the field. It is a contention of the petitioners that anything beyond that would encroach upon legislative judgment. Section 73 and 74 of the MB Act offer broad guidelines, cannot be construed as exhaustive in enumeration of all factors. Reliance placed on sub-rule 4 120 misconceived. It provides for special conditions of a permit. Conditions can be attached to a permit only when a decision to grant a permit is taken. Here the stage is pre-grant of permit, and the concerned sub-rule does not aid the petitioners for resolution of the present controversy. What is left for consideration is Rule 88, the policy for controlling and coordinating the matter of road transport that the STA is entitled to frame in terms thereof is hedged with the condition that the same has to be in tune with the directions of the state government. The RTAs, once such policy is framed, is also to regulate their functions and activities in a manner so the same conform to the directions issued by the state government. It follows as a logical corollary that without the direction of the state government, the STA is not empowered to frame any policy for controlling and coordinating road transport. The submission of Mr. Das that it is a function of the STA to frame policy for control and coordination of road transport is in ignorance of the condition precedent and does not advance the petitioner's cause. It is axiomatic that the directions of the state government in full measure in respect to the factors to be considered for grant of auto rickshaw permits were so long absent, which have been put in place by issuance of the input notification. Here, if we are to compare it with this, there are three things to be seen. The first is the Motor Vehicles Act, where Ms. Nag says that there are certain conditions mentioned and you can't go beyond that. It does say that the STA, while granting permits, is empowered to add any other condition it wishes. That is implicit in the Motor Vehicles Act itself. So if you watch it,
Similar provision, please.
Madam,
Act of
74. Section 74.
Yes.
The Regional Transport Authority, if it decides to grant a contract carriage permit, may subject to any rules that may be made under this act. Subject to rules that may be made. Attached to the permit any one or more of the following conditions, namely. Now the conditions are there, can we see 13?
Yes, I saw that, yes.
Now, my point here is, what Ms. Nag has said is that these conditions have to be prescribed in the rules. Only when the rules say that the STA make this rule, then the STA will make the rule. My humble submission is the Act empowers the state government, which has delegated its powers to the STA in terms of Rule 50. And if one is reading that in light of this decision, the whole point is that there is a void in the regulatory mechanism. 162 fills that void. And therefore, this act, even if it's not a legislative act, is something which is filling that void in terms of the law. Now, on the basis of this, the court comes to the conclusion that the court, the STA was competent to take these resolutions and uphold the resolutions. This far as Justice Doctor's argument is concerned. Now, in another matter involving auto rickshaws.
So what is the conclusion of the court?
The conclusion is that the contention that the STA has no power to make the resolutions is rejected. And thereafter, the court goes on to test the virus of the notification and again upholds that.
So the Justice Doctor's view was that the STA can go ahead and make these or rather can enforce the resolutions even without going through the rigors of a rule making
Statutory process. Now, this, if it is read in light of the references to Article 162, what is happening is, if we look at both the situations separately, in West Bengal, there is the Act, there are the rules. Under the rules, the state government made a notification empowering the STAs and laying down the conditions. Then the STA start taking resolutions saying these are the permit conditions that are there. You don't fulfill these conditions, we are not giving you the permit.
Yes.
Here, there is one step missing. That I agree. The step which is missing is a legislative step. That does not void the executive power here, which is coextensive with the legislative power. Now, this is a division bench judgment on appeal. This was with regard to Auto Rickshaw Owners Association in 2010. Here again, a rule of the West Bengal motor vehicle rules was challenged, the virus thereof. And here, your lordships would find that there were specific conditions which were being looked at. Now, with regard to the contract carriage permissions, paragraph 5 onwards, the court had considered the different statutory provisions with regard to transport vehicles and permits, which is pretty much what I had submitted yesterday. What is important is paragraph 6.
Yes.
A provision of the clause 2 of subsection 2 of 72 and clause 1 of subsection 2 of 74 dealing with stage carriage permit and contract carriage permit respectively empower the RTO in respect of both the permits to impose a condition that the vehicle shall be used only in a specified area and a specified route or routes. In view of this, it is not possible to accept the contention that sub-rule 4 of Rule 120 converts. So the contention is settled. What is important here is in 72 and 74, there is a list of permits which are an illustrative list. And then it says any other condition. That discretionary power of the RTO to impose or not to impose is what the court has upheld. So let us assume the RTO today says there's a list of 1 to 12. I want to put in number 8. We don't need any legislative mandate. We can simply take a resolution of this sort and say from tomorrow we are doing this.
No, I don't think Mrs. Nag is on the power of the RTO to do it. I think her argument is the form. As to how it can be done.
No. So again, the form is what I'm trying to address through Justice Datta's argument. But that line between statutory and a legislative act and an executive act is getting blurred. Now, it is something which perhaps is because of the very nature of the structure in ambulance, where you don't have a legislature. Here, the situation is, unfortunately, you would have in Calcutta the Vidhan Sabha taking passing a bill which gives rise to an act or a set of rules or whatever. The state transport authority is something which is run by the bureaucrats. It follows the statutory mandates, but this is an executive authority by its very nature. Here, the difference is there is no legislative one. So whatever is being done, what the Lieutenant Governor is doing today, the Lieutenant Governor issues a notification, he is invoking statutory powers, where the Constitution should delegated powers under the Union Territories provisions. But the same person is wearing two hats. Now here, for example, the constituents of this state transport authority are all bureaucrats. But there is no legislative mandate here because, technically speaking, who would make the legislation here in Andamans? It will go back to the transport department. The distinction here, this is unfortunately a constitutional conundrum which is there in the Andaman Islands. But this is not something which can be solved drawing a line and saying what you've done here is legislative, what you've done here is executive. That is why Justice Dr. came out with this quasi-legislative action. Now they are empowered to form bylaws. Let us say, for example, instead of having a meeting with minutes being recorded and those decisions being implemented, let us assume that written it on a letterhead where on top they just said bylaws of the State Transport Authority. Would it have changed anything? Apart from this, the nomenclature and the superficial appearance of what the form has fallen from the court, this is all that would happen. There is no legislative mandate that it will be passed by the Vidhan Sabha, that it would be placed before an authority. All that doesn't exist. It would be the same people signing it, but making it look a little prettier. Now, here, the same situation with regard to the powers of the RTA in this regard, all these permits, all these powers, the discretion that is there is something which the High Court is upholding again. Now, my humble submission is that discretion was delegated to the State Transport Authority in terms of the Motor Vehicles Act, which empowers the state government to delegate it. So once it is delegated, we will not challenge that delegation. Now, the manner in which I do it, technically we have not challenged it, although that is the actual challenge. Now, the manner in which I do it, when there is no prescribed manner, is exactly the vacuum that Justice Datta is talking about. And in that vacuum, someone has stepped in and taken steps. Now, in addition to these two, the only other decision which I wanted to place, to be very honest, part of it will go against me, but in the interest of fairness, I should place it. Manoj. There are a series of judgments which have evolved perhaps since 1950s, which are dealing with domicile as a reasonable and intelligible criteria for creating two classes. Now, they have been different at different times. To be very honest, it changes with the Supreme Court's benches. So initially, your lordships would find the first of these judgments was in 1955. That is D.P. Joshi versus State of Madhya Bharat, paragraph 17. Thereafter, the law evolved further in Vasundhara, that was in 1971. That is at paragraph 18. Subsequent to that, Pradeep Jain took a slightly different view with regard to postgraduate education, that is at paragraph 19 in 1984. The law evolved further in Anand Madan in 1995, paragraph 20. Jagdish Saran is referred to, which is again slightly different. And finally, paragraph 23, Saurav Chaudhary in 2003. Based on all those, finally, this court considers all the catena of judgments which evolve the law and talks about domicile. Now here, again, to make a fair submission, in certain arenas, domicile is required and is recognized. So this was in context of Assam, where a condition is put in that you must have studied in the state for 3 years, you must have stayed in the state for 10 years. Based on your residence, you are given seats in a medical college, or in terms of public employment policies and recruitment, you are given some preferential treatment.
Yes.
By and large, the Supreme Court's position has been that such.
Yes, sorry.
By and large, the Supreme Court's position has been that this sort of domiciliary conditions are acceptable in the constitutional framework and indeed may be required in certain places. The flip side to this, if I may be so bold as to say it, the Supreme Court diverges from itself on only one area, and that is the area of merit in postgraduate studies. That in a particular place, you may have seats being reserved where a domiciliary quota is not going to help quality. Where for quality, you have to go back to merit. With the greatest of respect, these people are not engaged in rocket science. In this entire thing, the object of this policy and the way in which it has been framed, that object is very much in tune with what is being done. And if one goes by the mandate of the Supreme Court, domicile as a intelligible criteria, even if one were not to look at parents' association, is upheld. So if today the Transport Authority here says that we make this condition for this reason, if the reason is something which is not arbitrary and the nature of the action is in tune, is in nexus with that object, and there is already an intelligible criteria and a distinct class, there is no illegality. So these would be my respectful submissions. In addition to this, if your lordship were to see
So how is this judgment against you as well?
it's against me because I said in terms of merit at higher studies, postgraduate medical courses, that was Pradeep Jain was divergent on that. But you can have domicile at the lower levels of MBBS and things like that. But when you have something like a postgraduate course which requires a high degree of skill and merit, then you take the best, regardless of where they come from. But that's why I'm saying that doesn't really apply for us here because there's no question of real merit as a consideration here. And again, these are things dealing with education and public employment. This is by no means public employment. But this is a public policy which applies to people in large and therefore can be tested on the same touchstones.
Yes.
Now, in addition to this, at page 2 of my note, your lordship would find the question that fell from your lordships was, has this criteria been the same over the years? Have they enforced it? Now, what I've done is from the vacating application, I have mentioned those pages and indicated the relevant portions. Each of the resolutions that was taken by the State Transport Authority is actually uploaded on the internet. It's available on their website. And many clients, the auto rickshaw drivers, have no access to these through the administration. We got them from them. Each of the criteria mentioned are considered again and again and again ad nauseum. These 5 that they have talked about, the first was 23rd April 2007, page 21. The next was in 2017, thereafter 18, 21, 23, 5 of them total. All 5 talk about the same criteria. The only change was when they raised the age from 40 to 50 in 2017. But what no one has mentioned, which I feel we need to mention, is this transport authority sits and meets once in 3 months, once in 4 months, every quarter. And there are meetings ad nauseum saying the same thing, implementing the same thing. So anyone who has got a permit has got it by applying within these criteria. So for example, I've mentioned the dates of some of the meetings that were held just between last year and now. We have only seen 9th of June 2023, but there were meetings in 2022, February 23, April 23, August 23, November 23, Jan 24. In each of these meetings, these criteria are consistently reevaluated in light of the representations that Mr. Chakraborty was talking about. Now, even with these suspensions, some of them have put in representations saying this is wrong for this reason. And to be very honest, I've gone through them and I find it really irritating. In some of them where someone's died, the widow wants to run the auto rickshaw through some other driver. The transport authorities are taking a very lenient view and saying, yes, this is a genuine case. It is in tune with the original meaning that the widow needs to run. So let the widow have the permit and let her use someone else to drive the auto. It's being allowed. On a case-to-case basis where it's required, it's being allowed. Whether this land thing, that you need to have a place to park the auto, you have to give an affidavit that you have a parking space. The person doesn't have land, who's a tenant in a house, who's giving that also, they're allowing it. The only thing that is being mentioned is the permits will not be given to non-islanders. And that is being echoed from 2007 to now. Apart from that, Manoj, I have discussed the rest of the issues that I have submitted yesterday. And finally, at the end, whatever Ms. Nag had submitted, I have just briefly dealt with that at the last page.
Yes.
So first of all, Ms. Nag had been speaking about the licenses and registration in addition to the permits. With the greatest of respect, licenses, registrations, and permits are 3 separate things. Now, the license to operate a vehicle is a very different concept from the registrations. The conditions there are something which are totally different. And to the best of my knowledge, Mr. Binay's repetition didn't deal with those. Registration, for example, is not connected with this. It's a corollary of this. Why? Because in order to buy an auto rickshaw, they will not sell you one till you have a no objection certificate, which is the precursor of the permit. You apply for the permit, you get a no objection certificate, thereafter you submit back and buy the auto, it will be given a number, then that is all entered into a permit and registered. So it's a corollary of the permit system, which doesn't have to be looked at separately. The second thing is with regard to the entire thing that these conditions are extra to the motor vehicles.
So, Mr. Kabir, let me do something. Let me go through the notes. If I have any issues, I will come back to you. Mrs. Nag, your quick response to what was
Very short reply.
yes.
Reply is that the judgments which have been shown by the other side, you actually would find that there has been a notification. And what legislative act has been explained, there, when act is passed, your lordship, that is to be placed before the parliament. So far as union territories are concerned, especially the Andaman Nicobar Islands, we know that president has got the power to make legislations. Though those are executive instructions, but in the nature of legislation because of the Constitution of India, that power has been given. That power, so far as Lieutenant Governor is concerned, that delegation is there in terms of rules. Rules can be framed by the Lieutenant Governor, and that is also mentioned in the Motor Vehicles Act itself, that rules are to be framed by the Lieutenant Governor. And STA comes after that. Once rules are framed, because prescribed, what other things may be prescribed? Prescribed means prescribed the rules. And what does the rule say? That it has to be with the approval of the UT administration. You can make bylaws. This is not even a bylaw. What respect it has got, I don't know. And what you are doing is you are making a difference between local and non-local candidate. Can it be done? Is it not a discrimination? And what
that is a second issue. Yes, Mrs. That will follow if the court were to hold that yes, you can pass these resolutions and they have yes, yes.
And one more thing, Your Lordship, that what has been explained, that by way of executive instructions, it can be done. Yes, sure, it can be done, but it can be done only as per Article 77. That executive instructions will be there and thereafter it will be notified.
And how do you react to Justice Doctor's judgment?
Notification is there.
Your lordship, we cannot say that the notification is there. Only on the basis of the notification thereafter resolutions were passed. Without notification, nothing was done.
I will do something, I will keep the matter tomorrow and then only reserve it.
Yes, sir.
You give your short response to these cases,
Yes, sir.
these decisions.
Yes.
So that I can give you one chance to,
Yes.
I'll give you the copies.
yes.
Shall I send you the soft copies? as well?
Copy based and send.
I'm not copy basing.
Learned counsel opinion for the respondent has relied on and has placed several additional decisions on the point of the power of the STU to issue to make policy decisions, without adhering to the without adhering to the requirement of form under the relevant rule. Stop. Next, list this matter tomorrow. Mrs. Nag, only how you want to distinguish those cases, that is all, and I will reserve it. No further.
Only making submission with regard to the decisions.
And have you added those pages in your note?
Yes, I have done it. Mentioned about the CAN number and WP number also.
What is the difference? Same thing, local card or whatever, that is the only condition, or is there some other difference?
One more is there. That the person who is purchasing the auto rickshaw, he only can drive it. Nobody else can drive.
But that condition is there, or
It's the original condition.
that's original condition.
Not original, subsequently it was introduced.
No, I just read it out. 2007 it was there.
2007 nahi hai. Subsequently it is there. 2021.
2021. And have you mentioned in your note when you got to go know about these policy decisions?
No.
You said that I have got to know only now.
When they started restraining us,
Yes.
from that time, I have mentioned it, I'll just brief it, Your Lordship. I'll do that.
Yes. Call on next matter. Yes, passed over matter, please.
Number 3, Sierra Tancheta, Control 3.
Yes. Supplement, please.
Number on WP 132 or 124.
Lord, here, the petitioner is the recorded tenant of the land.
Let me read the Indian order first, please.
My lord, it is at page 20, my lord. With an extra P5. The date is mentioned in the second page, my lord. Last paragraph.
What is the date?
Lord, second, tomorrow's date, my lord.
No, what is the date of this
Order, my lord.
31st January?
It is 31st January 2024, my lord.
So you said you got it on Monday.
Monday, my lord. This Monday, my lord.
Yes, so the order is for 31st January.
But on 5th, we have received, my lord. At Sarajdeep.
Yes.
Lord, the Tehsildar, kindly see my first, the Tehsildar has passed the same order on 10th of May 2023. That is at page 12, my lord, annexure P2. The same order. Page 12, annexure P2. P2. I have challenged this order before the subdivisional officer. As per the regulation, it is an appealable order. So I have challenged before the subdivisional officer. Subdivisional officer has upheld this order, madam. Upheld the order. It is at page 14, annexure P3. By challenging this subdivisional officer order, madam, I have read at page 13. Page 14 is the 14, madam. Yes. I have challenged this order before the Lieutenant Governor. It is at page 17, madam, annexure P4. I filed my appeal on 10th of Jan 2024, madam. Page 17, madam, annexure P4. 10th of Jan 2024. During the pendency of this appeal, madam, the interim order has been passed, madam. So there is no, what is the kind of, what is the date of the appeal? 10 January? 10 January 2024. I have not received any notice from the Lieutenant Governor. I have filed it there, I have filed it the appeal under the regulation. It is the second appeal before the Lieutenant Governor. Yes, Mr. Sivabalan.
Your Lordship, admittedly, there is no stay
No.
in the appeal filed by the petitioner.
Appeal is before the Lieutenant Governor.
Yes, Your Lordship.
What state? Lord, and the copy is given to the governor. Yes,
This is the appeal. Thereafter, I don't know what is the decision taken in the appeal.
my lord, appeal copy has been intimated to the Tahsildar also. I have annexed the, kindly see note 17. I have given the copy to the Tahsildar also. Seal is also there, and pen itself I have given service effect to the Tahsildar also.
And one important thing is that, Your Lordship, this order of to vacate the land, the petitioner is the owner of the survey number 226/4/1, whereas this order has been passed upon the survey number 226/4/2. This is the land belonging to the one Alka Turkey.
Yes, who is Sundari Devi? My lord, recorded, my lord, kindly be seen the first order. It is the same order, my lord. Annexure P2. There also the survey number, it's the adjacent plot order. No, but Alka Tirki is before the court. Not before the court. No, Sundari Devi. Sundari Devi, my lord, because here the order is passed to vacate my occupation. P. Sundari Devi, that is there, my lord, in the order. Where? In the Indian order also it is mentioned, my lord, last paragraph. No, but then it's written to Alka Tirki. But Alka Tirki is the adjacent plot order. Now the Tahsildar. No, when the first order, Tahsildar has come to the conclusion, where was your name appear in the Indian order? It is in the Indian order, last paragraph, my lord. Last paragraph, I hereby direct the revenue inspector, circle number 1, to remove the unauthorized occupation of Srimati P. Sundari Devi and Shri Binod Ghosh. Yes, so then who is Alka Tirki then? Alka Tirki is the adjacent plot order.
He is the recorded owner.
So it is on a complaint made by Alka Tirki? No, lord. No, lord. Then what are you saying all these things?
This land is upon which this order has been passed belonging to Alka Turkey. And as such, this application, this order has been.
Appeal is pending, my lord. Yes, I think I may be protected, my lord. This appeal is pending. Matter was listed. And the urgency shown by learned counsel appealing for the petitioner. Stop. A supplementary list was taken out. And a supplementary list was accordingly taken out for listing of the matter. Stop. Next. Mr. Sivabalan, who was present in court, was requested to appear
for the respondents. And the given time, and a copy of the writ petition was served on Mr. Sivabalan. Stop. Mr. Sivabalan was also given sufficient time to go through the writ petition. Stop. Next, the order under challenge in this writ petition is of 31st January 2020, 31/1/2024, passed by the Tehsildar, Port Blair. Stop. By the said order, the petitioner has been, Binod Ghosh is also a petitioner. No, my lord. The petitioner is one of two parties who have been removed, or who have been directed to be removed by the Revenue Inspector Circle, by the Revenue Inspector from the occupied land. Stop. The petitioner was to be removed by, is to be removed by tomorrow, by 8/2/2024 at 10 a.m., which is tomorrow. Stop. Next, the impugned order reflects that the Tehsildar proceeded to pass, give the direction for removal of the petitioner on a complaint received from one Alka Tirki, ALKA Tirki, TIRKEY, who has been described as the recorded tenant quotation marks in the impugned order. Stop. Next, learned counsel appearing for the parties, for the petitioner as well as the respondents, have taken the court through the relevant documents. Stop. Next, from the documents, it would appear that an identical, that the Tehsildar had passed an identical order on 10th May 20, identical order on 10th May 2023. Where is your name mentioned in this order? At page 13.
Directly the respondents, my lord, directly the respondent is mentioned. But I was the party, my lord.
Yes.
It is there in the first paragraph. In the first paragraph, my lord.
2023, directing the petitioner within brackets described as respondents, close brackets, respondents in the order, close brackets, to vacate the land by 25/5/2023. Stop. The petitioner challenged this order before the competent authority. Unsuccessfully challenged this order before the competent authority, which would be evident from the order passed by the subdivisional officer, South Andaman on 2nd January 2024. Stop. The petitioner immediately preferred a second revenue appeal under section 28 of the A and N Islands Land Revenue and Land Reforms Regulations 1966 before the Lieutenant Governor on 10th January 2024. Stop. A copy of the appeal was also sent to the Tehsildar, Port Blair. Stop. Next, admittedly, the appeal preferred by the petitioner is pending as on date. Stop. Next, hence, it is inconceivable as to how the Tehsildar, could have proceeded to direct removal of the petitioner from the land in question, bearing survey number 226/4/2. Particularly when the appeal is pending before the Lieutenant Governor, and a copy of the appeal was also served to the Tehsildar. Stop. Next. Therefore, on a balance of equities as well as the principles of natural justice, there shall be a stay of the impugned order dated 31st January 2024, which was received by the petitioner on 5th February 2024, which was received by the petitioner on 5th February, this will be within brackets, which was received by the petitioner on 5th February 2024, close brackets, till 3 weeks after the appeal preferred by the petitioner, the second revenue appeal preferred by the petitioner before the Lieutenant Governor is disposed of. Stop. The respondents are accordingly restrained from taking any steps in terms of the impugned order dated 31st January 2024. Stop. WPA 126 of 2024 is disposed of in terms of the other.
Server copy will be uploaded.
Yes.
Blind. You do this quickly, then I will.
Oblige, my lord.
Oblige, my lord.
Yes, passed over matter.
Item number 3.
Copy দেখেছো? Yes, 10টা দেখো।
Item number 10, WPA 83 of 2024.
My senior is appearing in this matter. This held up for court number 2, madam. Argument has been advanced by counsel.
Yes, so this is matter tomorrow. I spoke for on behalf of the petitioner. Next.
Item number 11, WPA 93 of 2024. Item 11.
No one appears for the petitioner. This is matter tomorrow. Yes, any matter, Mr. Kabir?
The next hearing matters are mine, sir.
Porter Dakarva?
Item number 12, WPA 685 of 2022.
That's yours.
14.
Yes, not today, next.
Item 13, WPA 224 of
No,
2023.
so it just recorded out. Nobody appears for the petitioner. This is matter tomorrow. Next.
Item 14,
14, my lord, I appear for the
No,
petitioner.
13 also, same order, 14.
14, I appear for the petitioner. This matter your lordship had heard briefly. It was a matter relating to a demolition where I was enjoying an interim order. Your lordship has been pleased to extend that interim order, and a report was called for from the Tehsildar of Mayabandar by the previous order, which I believe is Justice Ghosh's order. No one brought a report. Thereafter, your lordship was pleased to once again direct a report to be called for. We were awaiting that report.
No one appears for the respondents. Stop. The interim order granted by coordinate bench has been extended till 29 February 2024 by the order dated 31st January 2024. Just change that sentence. The order dated 31st January 2024 extended the interim order granted by a coordinate bench till 29 February 2024. Stop. What do you want, Mr.
My lord, this is a matter which actually should be disposed of. There is a simple dispute with regard to.
Very good. This is matter tomorrow. Mr. Kabir, just tell Mr. Sirabali to be here tomorrow, so that he comes ready.